So messy. Hi, Commissioner O'Brien. Good morning.
Hi, Commissioner Whitworth. How are you?
I'm good. How are you?
I'm good. Happy Monday morning.
Uh-huh.
Yeah,
Oh, there.
yeah. We all have the same reaction. Like, oh, that's what I look like. Oh,
It's like, oh, how did I age 8 years in a
Yeah.
month? And it continues to happen.
why didn't anyone tell me that that's how I looked?
I'm going to mute just because I'm going to do some typing right here, but I'm here.
Yep. And just so you know, Commissioner Ashby let me know on, I think maybe it was Friday, maybe it was Sunday. I don't know. That he can't be at the morning session. He's going to come as soon as he can. And I don't know what time he was thinking, but just as a heads up.
Do we think there'll be an afternoon session?
I don't think so. Nope.
I didn't think so either.
Nope. I do not. But so he may show up at some point, but he had protected the date, but the court pulled him in at a last minute thing that he can't not go to. So,
Okay. And I've recused myself from the first.
yeah, and we'll reflect that when we
Okay.
call the case.
Okay.
Okay. Hi, Commissioner David.
Good morning. Good morning.
Hey, can the person who is on the phone number 603 something, just let me know your name and what case you're here for?
Are we ready to call to order?
Yes.
Okay. Good morning. It's 8:30. I'm Deb Whitworth, and on behalf of my fellow commissioners, welcome you to this meeting of the Maine Human Rights Commission. Before we proceed with the business of today, I'm asking each of you who may have an electronic device, cell phone, pager, etc., to ensure that they're silenced now. You should have gotten an agenda, including the consent agenda. The consent agenda is a listing of cases in which no written arguments were made to the commission in the allotted period. The commission will vote on those cases later on this morning, and they will not be considered further today. The remaining cases on the agenda today are coming before the commission to determine if reasonable grounds exist to believe that unlawful discrimination has occurred. The commissioners have received and reviewed investigators' reports and any written submissions submitted within the allotted time. No new information or any written materials will be accepted today. Cases will be called in order on the accepted agenda. As I call each case, the party who has submitted a written argument will be called to the podium to provide the most relevant arguments to the case. The time is limited to 10 minutes. Time may be reserved to rebut opposing arguments, but the time limit of 10 minutes may not be exceeded. Procedural rules of the commission specify that your arguments may address only 1, relevant factual errors, 2, relevant omissions from the report of facts submitted during the investigation, or 3, relevant issues and questions concerning interpretation of the law. The commission allows parties who do not disagree with the investigator's report to rebut comments made by the opposite party. Please be advised that commissioners may ask questions, and please introduce yourself as you are called to give your argument. Thank you. And first off, we have to have a motion to adopt or amend the agenda and consent agenda. Is there a motion?
Before you call for that, Commissioner, typically if I have heard from complainants who wish to withdraw or get a right to sue letter after an investigator's report has issued, I will present them now, because if you agree to that, it will change the agenda. I did have one for today's meeting to present to you. You have 2 in your materials. One is a case that's going to be heard in June, so I'll actually present that one to you in new business. The other one is about a case that's going to be heard today, but the complainant, a day after asking me to present it to you, changed his mind and said that he did not want me to present it to you. So I don't need to present the one in, it's a case on today's hearing agenda, Kahn versus Hughes School Apartments. That request has been withdrawn, so there's nothing that would change the agenda.
Okay. Okay, thank you.
So we do need a motion to adopt the agenda. Agendas.
So moved. I move to adopt.
Is there a second?
I'll second. This is Jill.
Thank you. And commissioners, as a reminder, when we're doing remote meetings, I'm required to ask each commissioner to vote in a way that can be both seen visually and heard auditorily. So I'll ask each of you by order of seniority to vote on each pending motion. So this motion is to adopt the agenda and consent agenda. Commissioner Whitworth,
Yes.
Commissioner David,
Yes.
Commissioner Dusan,
Yes.
Commissioner O'Brien.
Yes.
Thank you.
Next, the minutes of the March 2022 commission meeting.
No, it's a April meeting.
Oh, yeah, that's a mistake. It should say
Yeah.
April. Sorry about that.
Should be
You're
April.
looking at the April minutes.
Is there a motion to adopt?
I'll move to adopt.
I'll second.
So it's a motion to adopt the April minutes. If you say yes, you're in agreement. Commissioner Whitworth?
Abstain, I wasn't at that meeting.
Okay. Hold on, just making a note. Commissioner David,
Yes.
Commissioner Dusan,
Yes.
Commissioner O'Brien.
Yes.
Amy, could we have our director's report, please?
You certainly can. Let's see. So you have a report from me regarding personnel. We've had some great folks join us. We have another brand new investigator on today's call. It's getting to be a habit. We have Angela Morse with us. I did not tell her. I was going to put her on the spot. So you don't have to do anything, Angela, but she's here and she's great. As are all, there she is. Hi, Angela. All the other new investigators. We've got Courtney, we've got Heather, and our existing investigators. Also, Alex, Jane, Kit, who's kind of investigator, kind of not. Lots of stuff going on here. We also had another front office staffer. It's the first time our front office has been fully staffed in a very long time, and it's delightful. And we have one more investigator position to hire for, and then we will be, all our current positions will be full, which is very exciting. For conciliation status of reasonable grounds cases, you have a report from Jane, which shows 4 cases currently in conciliation. Hold on. And 3 cases in which conciliation was not successful. We do not have any successful conciliation agreements for you to review today. For investigation, you should actually see a report, which is exciting. Melody has figured out a way to derive a report from our CIVI system, not even from EEOC's new system, which is just now starting to get reports online. We're actually among a few agencies, FIPA partner agencies, that are working with EEOC to troubleshoot their reports because we use it pretty actively. So we had 37 new complaints filed in April, 25 administrative dismissals in April, and 15 predetermination settlements, 11 settlements, so basically through our mediation program somehow, and 4 withdrawals with benefits. For litigation, I would ask that we take that after executive session. And then for new business.
Question, Amy?
Yes. Yes, Ed.
The right to sue letter,
Yep.
that's requested and you issue that, does
Yep.
that change whether the complaint is still pending?
It does. So a right to sue request ends our agency's investigation and basically is a dismissal of a case. So the way
Okay.
that procedurally, people file complaints with us because our statute and also the federal anti-discrimination statutes basically say that if a person wants to be able to proceed in court with all their possible remedies intact, they're required to go through an agency like ours in other states and municipalities. And they have to give the state or municipality a chance to sort of look at the complaint first and give a preliminary look at it, but they don't have to stay here if we can't finish. They have to stay 6 months. And so after 6 months, they are allowed to request a right to sue letter and opt out and go to court.
And that would be necessarily before we'd completed our investigation. Otherwise, they'd be in the category of us discretionarily approving a dismissal after we'd done the work and seeing whether there was public interest or something.
Yeah, I can only think of a few times when we have managed to finish an investigation before a right to sue letter could be requested. But
Okay.
yeah, most of the time that's after we've gotten sort of initial pleadings, but before we've had an investigator assigned.
Thank you.
So you can see on the reports you have, we did 11 right to sue requests and we do get a fair amount of them.
Yeah.
Two main things to talk about in new business. One is that the legislative session ended and a few things of note. The first is that the only bill the commission had put in, which was to address a state Supreme Court decision regarding the scope of the Whistleblower Protection Act, that it does apply, and I had always understood to apply in workplaces where there are collective bargaining agreements, unionized workplaces. We confirmed that that is the correct interpretation of the Whistleblower Protection Act when the Supreme Court case had put that into question, and the legislature passed a bill and the governor signed a bill confirming that people who work in union workplaces do still have the right to file complaints with us about Whistleblower Protection Act violations. There was a bill passed. It was not our bill. We testified neither for nor against. called the Crown Act. I don't remember the actual number, but it's a bill that's been introduced in a number of states regarding what are called protective hairstyles. And generally speaking, it was intended to address the issue of people who are Black or African American and have hairstyles that are protective. Their hair is prone to breakage oftentimes, or they may wear dreadlocks or afros or things like that. And there have been a surprising number of situations when they have been discriminated against, some very aggressively, like students having their dreads cut off, but people also being denied jobs and other educational opportunities. And so this bill has been proposed. I don't know how many states it's in now, but it was proposed here and it was passed and the governor signed it. And so that makes it part of the Maine Human Rights Act. We were already addressing that in our proposed rules. If any of you have read the extensive rules drafts that we provided, you'll see that that's protective hairstyles are addressed in employment, public accommodation, employment, education. I think that's it.
Amy,
Yes.
and regarding that, I think the last discussion, it was not just Afro-American hair.
Yes.
Is it limited to that, or?
It is not. No,
Okay.
it has always been our intent to be clear that we've always interpreted the Maine Human Rights Act to apply already to traits associated with protected class status, like hairstyles. And as far as we're concerned, a protected hairstyle could have something to do with religion. And we've had cases about people with dreadlocks. So we don't interpret protected class traits to be only related to people who are African American, but that was the intent of the Crown Act. And we did raise this issue during hearings that we thought it was a great idea, but we didn't want it to be limited to only one protected class. But yeah, the bill passed and it was signed into law. But we interpret people who have hairstyles or other expressions of their protected class status, that those may be protected, whether it's race, religion, other protected classes. One bill was not our bill, LD 982. It's a longstanding effort to expand. It's not really an expansion. It's, I think, the original intent of the Maine Human Rights Act to require public entities that operate services that are not open to the public. That's a lot of lawyery words, but most publicly offered service, most things that the state operates are open to the public somehow. Most services, most places, some are not, like correctional facilities or jails. And currently, the prevailing interpretation of the Maine Human Rights Act is that the Maine Human Rights Act protected classes do not apply to public entities other than disability. So the short version of that is that people who are incarcerated or in the custody of state or municipal correctional facilities do not have the right, under the prevailing understanding of the Maine Human Rights Act, to file complaints with our agency if they are discriminated against while in custody on the basis of race, sex, religion, anything but disability. And we've been working for years to address that, along with some very dedicated legislators. And we've not made progress. And once again, this will be the fourth year now, that bill has died. So we introduced it at the start of not this past session, but 2 sessions ago, and it died. We introduced it again. Actually, no, we didn't introduce it this time. State legislator, the assistant majority leader, Rachel Talbot Ross, introduced it, and unfortunately, it died again. So there's that. The last thing I wanted to ask to mention in new business, because we're almost out of time, I've somehow managed to just talk, there is, as I mentioned at the start, another request to withdraw. It's not a case that's on today, which is why it's a new business. It's for the June agenda. You have a memo from me. It's on E20-0269, Cowan versus a caring community. And as I do in almost every case, when someone requests a right to sue letter or a withdrawal after we've issued a report, I almost always recommend that we not grant their request, because the commission has already committed substantial resources and informing the public of what is and is not discrimination is part of our job. And that is my recommendation here, but I bring it to you for your vote. Hi, Ed. You're muted.
Sorry, I lost my cursor. Yeah, I'm a little troubled as to how do we make an informed decision without knowing the merits of that? Are we being asked to judge whether it's in the public interest or that there's stuff to do, or is it just fairly routine that once we've done the investigation, we ought to follow through? Which I'm beginning to think that it is, right?
That's a decision for you as the commissioners to make. Under our statute, until we issue an investigator's report, people have a right to withdraw or request a right to sue letter. And we're required to grant those. Once we've issued an investigator's report and publicized it, they don't have a right to do so, but it's within the commission's discretion. And it's for you to decide what you think is the right call here. My personal belief and my 10 years of being here has shown me that many times people get the report and then they change their mind, or and they decide they would rather not have it hashed out in the public eye,
Right.
which I can understand. Or sometimes they reach a settlement, but by then we've already gone through all the work of issuing an investigator's report, getting responses, and investigating the case. So that is the basis for my recommendation that you deny it, but that's up to you.
Okay, thank you.
Julie?
To prolong this, the one, we did, the case that requested to withdraw that's on today's agenda, we were able to read that, study that. Next month, is that going to be the same? I mean, we're voting today on whether to allow withdrawal or not, correct? On today's, will that be the same next month?
No. Okay, so the one that you're looking at right now is a case that will be heard in June. The one that I had presented to you for today's hearing, they actually changed their mind and told me that they did not want me to ask you to withdraw it. So what you're looking at now, Cowan versus a Caring Community, is on to be heard in June, and you don't have the report in front of you. All you have is a memo that describes their request and why they made it. Ed, you're muted.
The Khan case is on then?
Khan case is on for hearing. Mr. Khan advised the day after he asked me to present you with his withdrawal, he advised that he had changed his mind.
But we're still going to hear it.
Yep.
Oh, okay. All right. I misunderstood you. All right. Then that makes sense. Yep.
The only one I'm asking you about right now is one that you're not hearing today at all.
Right.
Which is why I
Right.
can ask you ahead of time.
Right. I got it. No, I
But
can.
my concern is that we'll get a lot more of these. We already get a fair amount.
No, I can support the hearing the merits if we've done the work and created a report and making a decision. So. Do you need a motion?
I do.
I'll move that we deny the request to withdraw in E200269 Cowan versus a Caring Community.
I second.
Thank you. So the motion is to deny the request to withdraw in E200269. So commissioners, I'll ask each of you if you are in agreement. Commissioner Whitworth,
Is it too late for me to ask a question?
Barbara says no.
Okay. So they won't be available to attend the June 13th meeting?
That is what they're saying. And I advised them that if commissioners denied the right, the withdrawal,
Yeah.
that the complainant could ask the other side if they had any opposition to continuing it to July. And
Okay.
then it would just be a routine, tabling.
Okay, great. Okay, yes.
Commissioner David,
Yes.
Commissioner Dusan,
Yes.
Commissioner O'Brien,
Yes,
Okay, so that motion to deny the request to withdraw. So I'll be in touch with the complainant to let them know that if they want to bump it from June, we'll talk about that. And that is all the new business. That took a surprisingly long time, sorry.
Okay, so we will now go into our cases to be heard. The first case, E20-0158, I have recused myself from. Not sure who takes over at this point. Is it Ed?
Oh, that's a good question. I did not prepare Ed for that. Ed, you're gonna have to unmute.
No, you did not.
Sorry about that. I forgot about that. If you want, I can do the bulk of the work, but really you're just gonna, and also the complainant is not here. But he did contact me this morning and asked me to read an email as his presentation.
So it's a no reasonable grounds recommendation. And therefore
Yes.
the complainant would be called upon first and objects to that. And he sent us an email.
Correct, which
I think- My instinct would be to allow that and read that.
okay, this is, I'm sorry, sir. Excellent. Your first time presiding. You're doing an excellent job so far. So the complainant's statement is this: Dear Commission members, thank you for your time and effort supporting the Human Rights Commission. My complaint before you was submitted when I received no support from my employer, the Girl Scouts of Maine, after my direct supervisor retaliated against me for having a safety concern about a newly modified wood splitter that I used during my normal work tasks. Coming before you pro se, I am not as skilled at creating a perception of the event like the counsel for respondent, and I am only seeking for the truth to be known. The slander of my work performance is the only way to distract from the incident contained in my complaint, but please refer to the verified documents that only reveal a satisfactory employee performance. After I raised the safety concerns about the wood splitter to my direct supervisor, I was supplanted by another supervisory employee present that continued my task to split wood, and I was not given another task before my termination. This protected conduct took place during the early days of the COVID-19 pandemic when restrictions were being put in place on our society. Being left unemployed with little hope for a new job quickly, I then applied for unemployment insurance after the Girl Scouts of Maine objected to my application and put it on hold. The Maine Department of Labor deputy found that I was eligible for benefits because I was not fired for misconduct, which confirms the content within my performance reviews. As I was a satisfactory employee by all records collected to the day of my termination, I would also like to highlight that my direct supervisor had given me a performance review 1 week before the incident, and that performance review has disappeared from my employee personnel file. Please do not be distracted by the slander caused by Respondents' Counsel that was created only after the protected activity took place. Thank you for your time, and I greatly appreciate this commission for hearing my complaint.
So, so complainant's not here. I think we call on respondent. Is there
Yes.
counsel for respondent?
Hi, Kathleen Wade here for Girl Scouts of Maine.
All right, Attorney Wade, you have the floor.
Awesome. Good morning, commissioners. Good morning, Executive Director. Thank you for having the Girl Scouts of Maine and myself here to discuss this case this morning. As I said, I'm Kathleen Wade. I would urge the commission to adopt the investigator's no reasonable grounds finding in this case for two primary reasons. First, the termination of Mr. Kinch's employment was for reasons that related to his disinterest in this job. He truly just didn't seem to want this job at all. And secondarily, because the supposed complaint that he made was actually not a whistleblower protected complaint. It was a complaint about a lack of comfort with respect to the log splitter. So I won't take too much of your time, but generally, again, as I stated, this is Mr. Kinch was very clearly unhappy in his job. He repeatedly made that known. He did not want to work the 24 hours that he was scheduled to work. He repeatedly asked how this job would look on his resume and was rude to his supervisor about it. He would argue about jobs that he knew that he was required to do that was discussed with him when he was interviewed for the job. The log splitter issue was literally just a continuation of this pattern. Specifically, what happened is that he was asked to split logs on a log splitter that he had used many times. I personally have never used a log splitter, but my understanding is that when you do so, you are required to operate the log splitter on the side that uses the lever, so that you do not reach over the active log splitter to use the lever if something is going wrong. And he had used it correctly many times. This time a cradle was installed, which is to catch the logs, and it was installed opposite the lever, so that again, nothing stood between the operator and the lever. When his supervisor came back from doing another errand with another employee, they realized that Mr. Kinch was using the log splitter incorrectly. They notified him of that fact, and he began to argue with them about how the log splitter was very uncomfortable if he operated it on the side, the correct side, essentially. He laughed at his supervisor, said he was doing his job wrong, and was just generally being disrespectful. So ultimately, the supervisor asked him to come into the cabin to talk about and look at the manual to talk about using the log splitter correctly. Instead, he chose to leave for that day. Again, a continuation of his clearly not liking this job and not wanting to do it. A couple days later, he returned to work and was called into his supervisor's office, at which time he repeatedly said that the log splitter was not comfortable to operate. He never made a safety concern, never said anything being concerned about injury. And, you know, as noted in the investigator's report, which again, we think is very good, this conversation was not very productive. It was recorded. So a complainant's representation that it was a safety concern is just not accurate based on the recorded conversation. His supervisor did try to explain to Mr. Kinch that this was a concern and it was a continuation of other concerns regarding his lack of interest in his job. And Mr. Kinch just repeatedly tried to argue with him. The conversation was very circular. Ultimately, the supervisor asked him to go home for the day. And instead of doing that, Mr. Kinch went to his truck, grabbed some water jugs and tried to get water from a spigot. His supervisor asked him what he was doing, and he basically indicated he was going to, try to go to a locked portion of the camp and get water. This was just, again, a continuation of the concerns, his inability to take this seriously, his rudeness towards his supervisor. And at that point, his supervisor decided that it would be better to not have Mr. Kinch sort of using a key to go look at locked areas of the camp, and decided to terminate his employment at that time. He was repeatedly told in the conversation that he was, again, not committing to this job, not making it look like he was committed to his job, and that the arguing was unprofessional. So ultimately, those are the reasons. There was no whistleblower protected complaint, and the reasons for his termination were unrelated to a complaint about the log splitter. It was the way he went about the complaint. But I'm happy to answer any questions the commissioners have regarding this case.
Thank you, Ms. Wade. Commissioners, if you have a question for Ms. Wade, raise your hand and I'll call on you in turn. Yeah, Commissioner David.
Yeah, does it turn on the factual issue as to how the cradle is to be installed? There are written instructions to set up the log splitter, but it seemed to me a little bit unclear as to whether that actually was in the record and was, that it was to be installed in the way contrary to what he was demanding. That seems to me to be the crux of the case.
Yeah, I don't think that it actually matters. I mean, I do think the log splitter, the cradle was installed correctly, because the one thing the manual does say is that you would never operate the log splitter on the side opposite the lever. But the cradle was a separate matter. I think the truth of the matter was the way that he went about talking to his supervisor about it. The supervisor recommended the two of them have a conversation, look at the manual together, and instead he was laughing at his supervisor, telling him he was doing his job wrong and refusing to look at the manual together. So it was really his unprofessional behavior that sort of circled around this log splitter issue, and not whether the log splitter itself was a problem. And I would again note that he never at the time, the only time he made it a safety concern was when he presented his case to the commission. He repeatedly said in his 15-minute recorded conversation with the supervisor that he was not comfortable operating the log splitter from the side with the lever.
Thank you.
Thanks.
Any other commissioner questions for Ms. Wade? Not seeing any. Thank you, Ms. Wade.
So do we go back? We can't go back to the complainant. So we go to the investigator, who is,
Correct.
Is that Attorney Crossman?
That is Kit Thompson Crossman.
Kit?
Morning, commissioners. This is the first of many times you're going to hear from me today. 4 of these cases are mine, or at least I've wrote the reports in them. So in this case, I don't have much to add that's not in the report, Commissioner David, to address your question. As far as I could tell, and I did look at the instructions, and I have operated a log splitter before, the cradle was correctly installed. And Attorney Wade is correct that the complainant repeatedly said that he was uncomfortable, not as far as I could tell in a safety way, but just like physically uncomfortable operating the log splitter in that way. But it wasn't clear that that was a safety report. And even if it was a safety report, it was very clear from the record that complainant was fired primarily because of his attitude, which was combative. So I'm happy to answer any other questions that you have.
Any questions for the investigator? Seeing none. Thank you, Kit. So commissioners, you have heard from the parties, you have heard from the investigator, and at this point, we will be looking for a motion. There is one proposed finding. Commissioner Doosan.
Move that we accept the recommendation. I'm sorry, I'm scrolling forward to make sure I read it properly. That there are no reasonable grounds to believe that the Girl Scouts of Maine retaliated against Dan Kinch for engaging in WPA's, well, whistleblower protection, Maine Human Rights Act protected activity, and the claim should be dismissed in accordance with 5 MRSA 4612, Section 2, Sub 2.
I'll second it.
So it's been moved and seconded to find no reasonable grounds. I will ask each of you if you are in favor. If you say yes, you're in agreement with the no reasonable grounds finding. Commissioner David.
Yes.
Commissioner Doosan.
Yes.
Commissioner O'Brien.
Yes.
Thank you. And Commissioner Whitworth is abstained or recused. So the finding is no reasonable grounds by a vote of 3-0 to 1. One abstention. Thank you, Ms. Wade. And the commission will send parties and counsel, there she goes, a letter confirming that finding. And Commissioner Whitworth is back.
Okay, our next case is E.
Oh, I was getting used to this, Deb.
Oh, you'll get your turn. Don't you worry.
Don't you worry.
Yeah.
The next case is E 20-0212. It's a reasonable ground recommendation. So is there anybody here for the respondent, Peter Cooper?
Yes, I am Norm Belanger, the attorney, and Peter Cooper is also on the line.
Just so we know, are you intending each of you to present or just Mr. Belanger?
I will be the only one presenting, but if he's
Okay.
here available for questions, if anyone has any.
Okay, you have 10 minutes, Mr. Belanger.
Hey, thank you, and good morning to all, and thank you for giving me this opportunity to respond to the proposed finding. Basically, there are 3 points I'd like to raise with regard to that we are in disagreement with the investigative report. The first one is as to the party, it's the wrong party. In this particular case, the investigator found that Peter Cooper individually was the employer on one basis. He was not the employer. The evidence is clear that it was Greater Brunswick Physical Therapy PA was the employer. We raised that actually right from the get-go to say, I think she's named the wrong party, but we're going to respond anyway with the expectation that she'll change. The request was made of her to change the party. She chose not to continue to name Peter Cooper individually as her employer, even though he was never her employer. He's a shareholder of the corporation, at the time, the sole shareholder of the corporation and a director. But basically, the finding is that under the Maine Human Rights Act, he nonetheless is the employer. This basically runs counter to the Maine Supreme Court. The actual citation in the Maine Human Rights Act in the footnote of the investigator's report was ruled by the Maine Supreme Court in Furman v. Staples that it does not create supervisor individual liability. Though the language may be ambiguous, the Supreme Court found quite clearly that only the employer, the actual entity employer, was liable. There is also a kind of implication in the footnote saying that effectively, since he's the only shareholder and the director, he is synonymous with the corporation. Likewise, Maine has had a long line of, what they call piercing the corporate veil. You do not find individual shareholders and individuals responsible for the acts of a corporation, absent a showing that the shareholder abused the privilege of the corporation, the separate corporate existence, and it would result in an unjust or inequitable result. There's no evidence anywhere on the record. It was never raised about piercing the corporate veil. This was basically a finding by the investigator. There is no evidence that Peter Cooper, the individual, was synonymous with the corporation, or that somehow he is personally responsible for the acts of the corporation as an employer. So that is point one. Point two is that even, whoever the employer did not, in this particular case, violate the statute. That, we admit that there is the prima facie case of discrimination was made, but then the obligation falls on the respondent to show that there was a legitimate non-discriminatory reason for the termination. In this particular case, the evidence is replete with evidence as to why there was a reason for his doing this. From the period from May 8th through June 21st, 31 work days, the employee was available 7 full days and 5 partial days out of 31 work days. Then from that period on, from June 21st all the way until July 17th, when she was terminated, she wasn't available at all. She was absent from employment for that whole period of time, and it wasn't clear at all when she would be again available. Her doctor had not cleared her yet. It wasn't clear when she would ever be able to come back and work again. The evidence also was replete with evidence that this was affecting morale. Because they were short a person, billing was falling by the wayside, finances was falling by the wayside, scheduling was falling by the wayside. So there clearly was a legitimate non-discriminatory reason for this termination. And let me also make clear, this is not a personal accommodation case. The investigator rightly found that she never directly or indirectly requested personal accommodation. There isn't a question about, did they give her enough time? Question, was there a legitimate non-discriminatory reason for which the termination was based? And I think the evidence is very clear that there was. Then the burden flows over to the complainant once again to show that that is merely a pretext. There is zero evidence, I contend, anywhere to show that this was merely a pretext. There's no evidence on the record anywhere that the claims that her unavailability was affecting morale, finances, billing, etc., is a pretext. So on that grounds, he met his burden of showing that there was a legitimate non-discriminatory reason, if indeed he was even the employer. And on that basis, there was no discrimination. And the final and third point is there is an attempt to try to basically say, okay, let's assume we're wrong and he's not the employer. He is personally, nonetheless, personally responsible for violation of the Maine Human Rights Act on the grounds of his own individual behavior. Now, in order for him to be personally responsible on his own individual behavior, one, he has to be acting outside of his usual employment duties. There's no evidence that anything he did was outside of usual employment duties. Everything he did was in connection with his being her supervisor and being the president of the corporation. There is kind of this implication that because he told her, once you're able to work again, please come back and call us, and hopefully we'll have something for you to be able to do. It cannot possibly be the rule of this commission that a willingness to allow someone who's disabled, once their disability is gone and they can come back and do the bona fide occupational qualifications, that if you express a willingness to bring them back, that is a personal discriminatory act for which you can be held personally responsible. That's the only implication here of the personal responsibility, if he indeed is not the employer. That, in our mind, is not an appropriate standard. A willingness to say, when you're able and when you can come back and be here again, please contact us. And if we have something, we would love to have you back. That could not be an independent ground, and I would hope, for a personal discriminatory act. So the three basic points: Peter himself individually was not the employer. Two, there was a legitimate non-discriminatory reason for the termination, which was not a pretext, nor is there any evidence that it was a pretext. And three, any individual acts that he did were well within the scope of employment. And two, didn't rise to the level of an independent discriminatory act. So thank you. I tried to make it as brief as I possibly could. I know you got a long agenda here today. And if you have any questions of either myself or Peter, if he's still on, we're happy to answer those.
Thank you, Mr. Belanger. Any commissioners have questions for Mr. Belanger? If so, raise your hand. I'm not, oh, Commissioner David.
Yeah, a couple of things. You said it's not a personal accommodation request for a no, not a personal accommodation, a request for an accommodation for the disability. Why isn't it? Why isn't she obligated to make that request?
But she is obligated to make the request. She did not. The investigator found, if you look at the footnote, I believe it's footnote 1 or 2, first footnote 2 of the investigator's report, the investigator found she did not either directly or indirectly request any accommodation, because she never said, please accommodate me in this particular way. And the investigator was very clear that there was never a request on her part for an accommodation.
Is your argument that that's fatal?
My argument is that, that it shows it's evidence of the fact that they were trying to act. They bent over backwards, in my mind, to try to accommodate her. I mean, the fact that they went 31 days and only had her available full-time 7 and part-time 2, frankly, if it had been a reasonable accommodation case, I think we would have proven that it was a reasonable accommodation. I'm just saying the investigator here clearly said, this is not a reasonable accommodation case because she did not make that request in any way, shape, or form. In fact, during the investigation, she said he should have just known that I needed this time off. And frankly, he did give her the time off. The time was provided to her for significant, huge periods of time. And we're talking about the first 31 days. And after that, we're talking about 3.5 weeks with no availability whatsoever and no horizon of when she would be back. So even if it were a reasonable accommodation case, I think we would have met that burden anyway.
A question that I want to ask of both sides and the investigator is, would this case be here if I was struck in the initial conversation, it says that she tells them before he hires her that she's scheduled for surgery. Would this case be here if they said, okay, let's consider this a trial period and see how the surgery comes out? And that was a condition of the employment. And it turns out that she had a bad result. It had a complication. We don't know why this turned to worms, but would that have been permissible?
I encourage the commissioners to gather information. I do want to discourage the use of hypotheticals just because it talks about facts not in evidence. It's things not before the commission, and Barbara can tell me if I'm way off base, but in the past, we've tended to encourage you not to use the hypotheticals.
I know you haven't, and I've been chastised for that before, but this is in the evidence that she says that she's scheduled for surgery, but
so just to be clear, Commissioner David is asking a question, and I want to be clear that we are not taking evidence at this hearing. So Mr. Cooper, if what you want to talk about is talking about what happened, so relaying of evidence, that's not what we're here to discuss. We're talking about what's in the investigator's report and the submission of disagreement. So if you have,
okay, I'll withdraw that, Amy. Do you think that the situation that do you agree that she has a disability?
Well, we agree that she was disabled at the time. Yes. I mean, she wasn't able to work due to, physical, her surgery obviously didn't go the way she had hoped, and she was not able to work. So she was disabled at the time and unable to work. I do think that is true. We're not going to doubt the fact that she was unable to work at the time.
Okay.
Thank you, Commissioner David. Sorry for chastising. It may be too much. Other commissioners with questions for Mr. Belanger right now? Mr. Belanger, you have about 3.5 minutes left after we hear from the complainant. I don't see any other commissioner questions at this time. So at this point, we would turn to the complainant, and I see Miss Ellis, her picture. Miss Ellis, can you unmute? And
Hi, can you hear me?
yes, did you want to be on video or no?
No,
Okay, so
that's
you have
okay.
10 minutes, and I forgot to remind everyone, and Mr. Belanger, you did fine at this. I wanted to remind everybody who has a hearing today not to mention the names of third parties or witnesses in the investigators reports. We use a pseudonym for all the people involved other than the named parties. So please don't mention the names of any witnesses. The only names you can use are people who are named as parties. So with that warning, go ahead, Miss Ellis.
Okay. Thank you for allowing me to be here and hearing this case. Just a couple points of what was said. There was an email on June 5th that was submitted by Mr. Cooper and with his paperwork, that there was a request for accommodation indirectly because of my direct request towards the employees that I worked with. Obviously, working right to full time was not in the cards for me at that point because of my illness. So because of the juggling around with schedules, I had asked them, based on the work that I can do, what scheduling will work for them. I know that they were coming from other locations to cover me. So we were trying to figure out in person when I was on schedule and in the office, what would work. On June 5th, there is an email that, like I said, was submitted between the other employees and Mr. Cooper, knowing that I was having difficulty with my surgery. Can we think about offering her more time? Short-term disability, anything like that. I have highlighted document points as well. And here, another employee said that they agreed with that, maybe additional few weeks to come back well, so I wouldn't feel anxiety over being there, because this particular employee knew that I had depression and anxiety and that I was obviously feeling sick, but then feeling even more sick on top of that with my anxiety, not being able to help them with these complications that arose. Mr. Cooper denied those requests in that email and said, quote, to continue what you're doing and hope for that I turn out for the better. So there was a direct and indirect request with employees for accommodation that was denied. Also, that there was confusion, I guess, on what my actual termination was. Mr. Cooper shared with the employees that I was on a per diem status with no hours. That was never communicated to me. There's multiple points in here that shows that communication was broken. I was never given those words until this case came up. It was offered that I could go back afterwards once my disability was gone, but I do not believe that that would have been appropriate just because of how things had transpired. I wouldn't have felt comfortable going back after everything that happened with broken communication and just the anxiety that it caused, knowing that they were kind of against the wall with me being gone unknowingly. I did tell him, Mr. Cooper, that I would be out for surgery before I was even hired, because I want to be transparent that this was important to do and that it would cause me to be gone. I didn't have a disability up until my surgery. There were major complications from it. It's submitted also in the paperwork that Mr. Cooper, being in a medical field, knows that there can be unforeseen complications with any kind of procedure, which is what happened to me. There's less than 7% of people that get my complication with my surgery. So my disability wasn't present then when he asked me at hiring, but obviously it was developed. And so that point is kind of moot, that that there was a question of whether I had a disability at the beginning or not, because it was developed afterwards. They also did not hire anybody after I had left. They had other employees cover for me, and they never hired another person. They knew that they were closing some locations, so they used the rest of the lease to kind of clean up and get out of that office. So there was no it's confusing that they want to say that it was that I made a hardship on them without actually hiring anybody else afterwards. And as far as Mr. Cooper being the employer, as far as I was informed by Mr. Cooper and other employees, he was the kind of seal and deal. He was the only one making any kind of business decisions. So I was the only one he at least addressed as employer, as supervisor, as all these different hats. So them kind of picking and choosing which way they want to present is confusing, just because I was never told otherwise until basically today that he wasn't going to use that hat, but he was the only one in charge of hiring and firing. There's also an email from one of the employees saying, you're the decision maker, you know, you make all the decisions, you make the decisions of hiring and firing. So even by that submission, he's the sole decision maker. There's also, and like I said, just to quote what was said before, that he should have known, quote unquote, about my disability. He should have, just because of him being in the medical field. That's what they submitted earlier. But also, like I said before, I directly and indirectly asked. So he didn't need to know just from his own knowledge. There was a request made by other employees and myself. And like I said, I was transparent as much as I possibly could. I emailed with my statuses. I emailed with what I could do and when I could be there. Mr. Cooper never mentioned that there was a hardship until my termination email. So I had no way of knowing that things were, how things were, whether there was a hardship or not. But they were obviously very transparent with each other in their employee emails that were submitted. So it's just very, even today, it's still very confusing on what is true and what is not, just because I'm being told something different than what the employees were being told and shared with. Also, they did send an email after the investigative report asking for a mediation once they heard that there was reasonable grounds.
Hold on, Miss Ellis, that's not in the record and also not something that is allowed to be discussed under the Maine Human Rights Act.
Okay, I apologize. Since it was in the investigative report and in the emails between the three of us, I thought that would be a point to make. So I apologize if that was not allowed. That would have been the last point. So I guess I have nothing more.
Okay, I will ask commissioners if they have any questions for you. Hold on just 1 minute. Any commissioner questions for Miss Ellis at this time? If you do, commissioners, raise your hands and I will call on you one at a time. Any commissioner questions for Miss Ellis? Commissioner David.
Miss Ellis, you said you were unaware of the claim of a hardship. Had you been aware of that, would that have changed your availability to work?
I'm sorry, the sound bite cut in and out. Can you repeat your question?
I believe that I heard you say that you were unaware that they claimed that that your absence was causing a hardship in terms of staffing. And my question is, had you been aware of that, would that have changed anything in terms of your availability to work?
No, I was sick. I was going to the hospital every other day. I was admitted twice. I was on a feeding tube.
Okay.
There was no way for me to be there if I wasn't already there. And as stated and submitted, I was there for partial days because I wanted to be there. Just that my point for that was just that there was brokenness of communication. I was letting him know, hey, I'm at the hospital now. Hey, I got admitted. But there was no reciprocation of communication. And I was excluded from a lot of these emails and conversations of the scheduling. My only point of that would be that maybe that would have helped me kind of ask again for saying, hey, can I come? I can come for maybe an hour and do, or 2 hours and do some billing, or I can come, at some point in the week after I get out of the hospital. And I felt better for maybe one day after I got out of the hospital. So I could come that day and do some billing, but it was all or nothing pretty much. It was either I'm there 40 hours, Monday through Friday, or I couldn't be there at all. So that might have helped me kind of reiterate to him after the fact, like, hey, if they're so stretched thin, can I come in for an hour? Can I come in for 2 and try to at least take some of the burden off? But that would have been a technically third request because I had requested directly, employees had requested indirectly. So that would have been just another attempt to try to help. Other than that, the requests have already been made and they were denied from me and from other employees. So wouldn't have changed. But
Hold on, commissioners, I just want to remind you, everything that she just said is not in the record and didn't happen. So to the extent that it's helpful to you in your considerations, just keep that in mind.
Amy, if I may say that email that I'm referring to was submitted by Mr. Cooper, the email between
Yes.
himself and other employees.
I just mean the whole hypothetical proposed to you of what you would have done.
All right. I just wanted to make sure I understood. Thank you.
And a second question, you made the point of saying that they did not hire somebody else to fill your position. And I'm not sure, my question is, what significance is that? Doesn't that show that they're waiting for you and accommodating you?
Well, that's part of my discussion of how confusing it was, that communication was confusing from them, saying that there was hardship, but then emails and the fact that they didn't hire someone, how hard pressed could they have been? Also, like I said, that they were through an email, from Mr. Cooper, that they were closing other satellite locations. So it was reasonably assumed that I was not going to be needed afterwards once they finally closed those in July or August, I believe, when the lease was out. So that was just my point of the confusing and broken communication from them.
That's all.
Thank you, Commissioner David. Any other commissioner questions for Ms. Ellis at this time? Not seeing any. Ms. Ellis, you'll have about 2.5 minutes left. Right now, we're going to go back to Mr. Belanger. Mr. Belanger, you have about 3.5 minutes.
Yeah, just 2 quick points. One, with regard to her not knowing who the employer was. I mean, it clearly was on her paycheck that was on the door. And frankly, we did ask and raise the question right at the get-go. The investigator asked her, did she want to amend her complaint to include the employer, since she hadn't named the employer, and she specifically chose not to. So I think I just want to point that out. Yes, the office did close. Economics changed after the fact. They were having a tough time. They ended up closing an office and needing one less person, though that is really doesn't go to the point, and there's been no evidence presented that there wasn't a legitimate reason for her termination, and it wasn't just a pretext. There's no evidence whatsoever, again, that this was a mere pretext. My only point at this point. Thank you. Thank
you. Any commissioner questions? Oh, Commissioner David, there you are.
Yes, I failed to ask you before, but you just brought it up again. The business about the corporation and him personally, your argument is, am I correct, that in this form, this is fatal to say that the finding is against him personally? In other words, you're saying that's illegal.
Yeah, that's exactly right. It's fatal. He cannot be held personally liable under the Maine Human Rights Commission.
Right. I just want to make sure that I understand that that's the argument.
That is my argument. Yes. Thank you.
Thank you.
Any other, Commissioner Dusan?
Given what's in the record of communication between the parties, I don't quite. I suppose this is a question for the investigator. I'm curious to know about the finding that there was not a request for accommodation. I suppose the question I could ask Mr. Belanger is if this series of email communications occurred, am I right in understanding that it is his position that there was no request for accommodation, that these communications don't amount to an interactive process around under what terms she could return to the office? It's simply about availability or not availability.
Correct. I mean, there was never, and the investigator clearly during the investigation asked the question many times, did you ever mention to him that did you request an accommodation? And she, at that point on the record, said, no, I did not make a request for an accommodation. Which is why the investigator found the way he did. There was no ever formal or informal request for accommodation. Nonetheless, she would call and not be available. They knew that she wasn't available due to, whatever had happened in her surgery. She didn't give details, nor did they ask for any. So they were trying as best they could to cover the open spots for as long as they possibly could, but there was never a request for accommodation.
Mr. Jusant, did you have a follow-up?
Yeah. I suppose I'll ask the investigator. I don't understand why the apparent ongoing discussion of availability to work or her ongoing communications to the respondent regarding her availability to work, which changed depending on her health status at the time, is not why that discussion is not a discussion around accommodating based on work hours, accommodating work schedule.
And I'm sure the investigator will be happy to share their thoughts with you when we get to that in a few minutes.
Thank you, my dear.
Yeah. I see Kit is taking careful note. So any other commissioner questions for Mr. Belanger at this time? Seeing none. Thank you, Mr. Belanger. Ms. Ellis, you have about 2.5 minutes left. You don't have to use them, but you can. You're currently muted.
Thank you. I thought I hit the mute. Yeah, just to reiterate that, and that's one reason why I did want to speak, is because of that point that there was no request. There, like I said, and we'll reiterate, there was a request and it was denied. It was requested through the other employees because they're the ones who are making the schedule to accommodate me being out. So the accommodation request went to them to present an idea to Mr. Cooper. Mr. Cooper wasn't directly involved in saying, okay, we need, this many people here and we need to get this done by the end of the week. He wasn't involved in the day-to-day. It was based on these other employees. So I requested through them, what can we do? What will work for everybody, and let's present it to Mr. Cooper. That's why that June 5th email happened that he submitted, and that saying to say maybe I should take a couple more weeks. We can, I don't want to read the entire email, but 3 of the employees had said, why don't we do this? Why don't we do this? And the last email in that chain is that Mr. Cooper denied that and said, continue doing what you're doing, which obviously was not working for the other employees. And that's why everything was presented to him. So like I said, it was requested directly and indirectly, but it was denied on that June 5th email that was submitted. And as far as him being solely responsible, he is solely responsible because he was the sole decision maker. He presented me when I interviewed with him that he was employer, he was president, he was my direct supervisor. He mentioned all of these different titles. So up until now and continuing, he was my sole decision maker based on my employment there. This wasn't a huge national corporation where there are CEOs and multiple, locations in different states that have to communicate together. the sole decision maker. So he was the only one that was presented to be responsible as far as what was told to me.
Ms.
Um,
Ellis, that's
Yep.
the end of your time.
Yeah, and I'm done. Thank you.
Okay. Any commissioner questions for Ms. Ellis? I am not seeing any questions. Commissioner Dusan, are you?
I think I'm fine, actually. I reminded myself of the investigator's recommended finding, and given that, my question looks past that to ask for some more details, and I don't think it's necessary, given the finding.
Okay, any final call, any commissioner questions for Ms. Ellis? Seeing none, thank you to the parties and council. Now we'll hear from the investigator.
Great, thanks. On the reasonable accommodation thing, I think I can address why this is so confusing. Discussions about accommodations were happening, but they were not happening between complainant and respondent. So complainant may have had conversations with her coworkers about what would work. And it is in the record that respondent had some conversation with complainant's coworkers about adjusting schedules and maybe giving complainants more time off, but that never got communicated between the two of them. So there was never a request made to respondent about a reasonable accommodation. And even though respondent seemed to be considering them, and there is some evidence in the record that he considers that he gave her one, that was not communicated to her. So that's why there's no reasonable accommodation discussion in the report. There we go. Okay. I'm happy to answer any questions that you have. So I will just say I did not investigate this case. I wrote the report, but I was not the investigator. So I can answer questions as to what is in the record and what I've written in the report. I will say, I guess the other thing is that there's some dispute as to whether or not complainant was actually fired. That thing about her being on a per diem as needed thing was never communicated to her. The language that was used to communicate to her that she wasn't going to be coming back to work certainly sounds like she was being fired. The thing about whether or not she could come back to work, first of all, the rule is not that you can come back to work when your disability is gone. And it was indicated to her that there wasn't going to be any work to come back to because the office was closing. So while that offer was made, you can come back when you're healthy enough to work. There wasn't actually any, she had reason to assume that there wasn't going to be any work to come back to because the office was closed. Okay, now I will answer your questions.
Commissioner Dusan,
I hesitate to ask this.
can you speak up a tiny bit?
Sorry,
It's hard
I
to hear.
hesitate to ask this because I believe I understand the report and the drafting investigators' findings. But there's been a lot of conversation in this hearing about whether or not the respondent is the right party.
Mm-hmm.
And so I'm having a little trouble marrying that, the notion that the respondent here is not the party, with the respondent's apparent individual and personal engagement with the other staff and the complainant regarding her absences and her potential to return to work. Was there somebody else here that she should have been interacting with? Or I just don't get the argument that, yeah.
Sorry.
Yeah, go ahead. I'm sorry.
Okay.
I'm confused, and thus my question sounds confusing. It reflects my confusion.
So as far as decision-making authority about whether she was going to be coming back to work, who made the decision to let her go. The only person who is responsible for that is Mr. Cooper. He was the owner of the business, and those decisions were his responsibility. That's
what I
answer your
understood
question?
from the record. Yes, I was trying to marry that with the.
Yeah.
Mr.
So
Blanchard's
it's a little different from Furman in that he's not a supervisor. He is the owner of the business. And Barbara, I'm happy to have you say more about that if you'd like.
I wouldn't like. I don't think there's much more to say. I mean, Furman speaks to no liability for individual supervisors, but that is different when the individual is the business.
And the court in Furman was pretty clear that it was because supervisor wasn't in the statute that they couldn't be held liable. And here he's not the supervisor. He in fact owns the business. So he is the all of the language in 4553 is about a person acting in the interest of any employer such that the person's actions are considered the actions of the employer for purposes of liability. And while that might be not the case for a supervisor, he's the owner and the sole decision maker for the business.
I thank you. I thought that was pretty clear in prior cases, but then I set that aside in the response to Commissioner David's question to the respondent's counsel regarding whether this argument amounted to what he thought to be a fatal flaw in the case.
Speaking of Commissioner David, Commissioner Dusan, are you all
I'm
set?
done. Yes.
Okay, Commissioner David.
Good morning, Kit. What you just seemed to say, that he's the owner and making the decisions, it seems to me that you're concluding that therefore he's personally responsible because he's the person. I think on the contrary, everything that we've heard is that the business made this decision. And yes, he owns the business, but I am that doesn't pierce the corporate veil. That doesn't mean it wasn't a business decision. You've shown no personal animus for him acting outside his business role, have you? That's the question.
Well, Barbara, sorry, I thought I saw you. I think here, you can jump in at any time. So it is this case is a little convoluted, and respondent is correct that the investigator in this case did ask complainant if she wanted to name the business, and she did not. She named Mr. Cooper. I think the argument that I just made to, or the facts as I laid them out to Commissioner Dusan support the report that he, 4553, pretty clearly states that he can be held liable here. He's not a supervisor, he's the owner of the business, he's the decision maker for the business. And I think there is support for him being found individually liable under 4633 because of his ongoing communication with her about you need to be fully recovered, you need to be able to work a full-time schedule, could be considered an independent discriminatory act. Barbara, anything you'd like to say?
I guess the same question in a different form is reading your footnote 1. You have concluded that she has the option to say, I don't want to. I mean, she's been asked many times, aren't you suing the business here?
Yeah.
And you conclude that she has the option to say, no, I don't want to do that. I only want to sue him. I only want to make a complaint against him personally. And I am struggling with that.
Yeah. Understandably. Her reason for not suing the business was basically she really liked the business. She really liked working there. She really liked the other people who worked there, and she didn't want to name the business for that reason.
Yeah, she didn't want to say that the business discriminated against her.
Yep.
That's not the standard.
Barbara, did you?
No, I think that this is. Oh.
You were unmuted. Yeah.
You were.
Okay.
I saw that you were unmuted and would love to hear your thoughts on this.
I got that impression. Despite my refusal to have any thoughts about this matter, I mean, Kit did the best they could with the record as it existed when they inherited the case. And the record is not entirely clear as far as this whole piercing the corporate veil and whether Mr. Cooper is in fact the employer, as in the alter ego of the business. What information we have is in the report. The same with 4633, which is normally how we would proceed against an individual, at least one who is not the owner of the business and being treated as the business, is whether or not there's enough evidence. And again, all the evidence that exists is in there, that he went beyond sort of the role of a normal employer in making these statements and expressing his desire not to have complainant back unless she was fully recovered. Those sorts of things, which can be, but are not. It's certainly not the clearest case we've ever had as to whether this is interference or not. But we do, you have correctly stated that we do look for something that goes beyond their normal role as the employer. So whether these statements do that or not, we found, given we being, not me, but the royal we found that there was enough there that went beyond the scope of, simply letting someone go and expressed discriminatory opinions. But that is not, as I said, as clear cut as we have seen other cases. You also can find reasonable grounds on one and no reasonable grounds on the other, depending on how you see Mr. Cooper's role. If you see that there is a reasonable grounds case here, I've probably just made matters more confusing, but here we are.
I will also just say that because the statements by Mr. Cooper were so clearly, you can't come back to work because you've been out too many days because of your disability, that and because our standard is 50-50, that that's why the report comes down where it does, in terms of the respondent being liable as the employer.
Commissioner David.
Counsel just said, Attorney Hirsch just said, well, you could find one and not the other. There's not two proposed findings here. There's only one, and it's the wrong one, I believe. I'm tipping my hand, but there's no possibility of finding, taking two allegations separately and saying I'm not even sure I know the name, whatever physical therapy, whatever the name of the company was, discriminated. So enough said. That's the way it's presented.
If I could just say procedurally, no, there is not presented to you. The company is not named as a respondent, so you don't have the option of finding that entity responsible. I think
exactly
what was mentioned is that in the proposed finding you could see them as either or and, that you could find that Mr. Cooper as the employer discriminated against Ms. Ellis based on disability, and or that he interfered under 4633 with her right to be free of disability discrimination. You could see them as alternates.
Oh, I see. Okay, thank you.
It is what I meant. It may not have been what I said.
Any additional questions for the investigator? Seeing none. Oh, sorry, Commissioner Whitworth.
Sorry, I'm having a really hard time sorting out what Ed was just talking about, how to separate Mr. Cooper from the actual company. I understand that he is the company, but I'm not really understanding the supervisor liability here. And And I'm wondering why the company name isn't the respondent.
Because the complainant, in every case that comes here, the complainant chooses who to name as a respondent. They have that choice. Many times folks name individuals that are part of their employer, but are not the actual employer entity. We try to be clear with folks that if they name an individual, that there's different roles, and we can't give them legal advice and say, if you name the individual and not the respondent, they may not have any money or liability. But people make a choice of who to name. The complainant here made a choice of who to name. She was given an option to change who to name. She chose not to.
Okay.
And anything, did that answer your question, Deb? And you said something about supervisors, and I wasn't sure if you wanted
Yeah,
me to.
sorry, I don't, yeah.
Well, I am still just, I don't mean to be so thick where this is concerned, because I've obviously been on the commission for quite a while, but I don't recall having a case in a decade where there's been supervisor liability just as the supervisor and not having the company also named. So I'm grappling with that, and unfortunately, I am not being successful.
So here, and this is, as Barbara and I have been saying, it's not the clearest case we've ever had. So I think it's totally understandable to be grappling with this. In this case, he's not. So when we have cases that name supervisors, generally those supervisors are not also the owner of the business. Usually there's somebody sort of in the middle. And so Furman is very clear about the word supervisor isn't in the statute, and so supervisors can't be held personally liable. But in this case, respondent isn't the supervisor, he is the owner of the business. He also happens to be the person who makes decisions about hiring and firing and that sort of thing. But he's not just a supervisor, he's also the owner of the business. And I'm sorry if that's made it muddy.
Yeah, I mean, you're right, Deb, and I don't know that I recall in a slightly shorter, but not that much, a period of time, seeing a case like this. Either normally we would have entity, employer, and a finding of discrimination or not, so we would know what the employer is responsible for. And then any additional allegations are usually against mid-level supervisor, and you can compare them to what, you know, a real mid-level supervisor would do. And is there something extra? Did they go beyond? And we've had a lot of those cases, and you compare it to what their role would be in the company and whether they did more and whether that more was enough to amount to interference. The problem here is that it appears, again, from the limited information in the record, that Mr. Cooper had all of the authority of the employer. And so looking at him as an individual, it is very hard, if not impossible, to totally separate those out. All of which is to hopefully explain a little and to confirm that you are not being thick at all.
No, this was, yeah.
Any, yeah, Commissioner questions? Commissioner Whitworth, or did you have a follow-up?
So with the finding of the recommendation for a reasonable grounds finding, so we are looking at him as the individual versus him as the owner of the company.
Yes.
Those are, yes, I guess those are the two choices. The one, finding interference would be considering him in his role as an individual. And again, this is such an awkwardly situated case. While as to find discrimination, the discrimination claim runs against the employer. And the question is whether or not he is sufficient to be the employer.
if this was against Peter Cooper LLC, it would be a much easier case to decide on.
Agreed. Also, if it was against whatever the business's name is
Well, right,
and Peter Cooper, it would be a different case as well.
yes, okay, well, thank you. Okay,
Any additional commissioner questions for the investigator or counsel or the investigator counsel?
Yes.
Yes, Commissioner Dusan is still here. Yes.
Yes, with all of this, I'm asking the investigator who prepared the report, in the end of their analysis paragraph references the even chance standard. Can you wrap that up in a bow for us as well, given the back and forth around these basic elements?
Sorry, which paragraph are you referring to,
In
Commissioner
the
Dusan?
analysis paragraph on page 3,
Yes.
the investigator reminds us of the interpretation of the reasonable ground standard to mean that there is at least an even chance of complainant prevailing in civil action. The investigator doesn't refer back to that later in the report, but I want to connect that reference, that reminder, to the reasonable grounds recommendation, if you would, please.
Sure. Yeah. So because we have a 50-50 standard, that's what we've interpreted the reasonable ground standard to mean, that there's at least a 50-50 chance of complainant prevailing in a civil action, is sort of the only thing that makes this case a little bit easier, right? That we have this standard, that there is at least a 50-50 chance. Not a preponderance, not a 51-49, but that is why I think we were able to get to reasonable grounds in this particular case. And it's not a clearly situated case, and it is, as Barbara has said, the facts that we have are in the report. That's as much of a bow as I can wrap it up in, I guess.
Thank you. It's just that
Sure.
because it appeared in just one line in the midst of the investigator's report, I thought it important to just have a little, what you have provided, a little bit of an explanation here on the record with the complainant and respondent listening. Thank you.
And the even chance, I would say, applies to all the elements of this. So it's finding respondent to be liable as the employer and liable for discrimination, and that discrimination occurred.
Thank you.
Sure.
Any other questions for the investigator? Commissioner David?
No, I'm getting ready to make a motion.
Oh, okay, proceed.
I want to make sure I'm not cutting anybody off. I'm going to make a motion that we find that there are no reasonable grounds to believe that Peter Cooper discriminated against Jessica Ellis based on disability or interfered with her rights, and that the complaint should be dismissed. And I will speak to that if it's seconded.
second,
Go ahead, Commissioner.
This is not a technicality. This is not a gotcha in terms of complainant's complaint that she didn't know what she was doing and that we're being tricky and saying, aha, that you can't do it that way. She made a conscious, clear decision after it being pointed out repeatedly that this is an employment situation and you're employed by a company. And she says, no, I don't want to do that. She chose the basket, and she had 2 baskets, and she chose to put all her eggs in the wrong basket. This is clearly him acting, all of the indications that he's the sole authority, he's the hiring authority. Yeah, that's his role. That's his role in the company. I'm comfortable in doing this because, and I'm not fully clear about the underlying facts. I'm troubled about the lack of accommodation issue. It's clearly not a pretext to me for discriminatory animus that he takes this action with this factual record. So I'm not uncomfortable with this decision, but I'm fairly clear that this is that she refused to make that election, and that that there's no reasonable grounds to believe that Peter Cooper individually should bear this tag.
Any other discussion among commissioners? Seeing none. So the motion is to find no reasonable grounds to believe that unlawful discrimination based on disability or interference occurred. If you say yes, you're in agreement with the no reasonable grounds finding. Commissioner Whitworth,
Yes.
Commissioner David,
Yes.
Commissioner Dusan,
No.
Commissioner O'Brien.
Yes.
So by a vote of 3-1, the finding is that there are no reasonable grounds in this case. So the commission will send the parties and council a letter confirming that, and that concludes this morning's hearing. Thank you for everyone and for your participation.
Thank you all very much.
Moving on to our next case, E20-0223, Joan Kelly v. Oxford County Sheriff's Department. This is a no reasonable grounds finding. Is there anybody here for the complainant?
Yes, Your Honor. Your Honor. Thank you, commissioners, for hearing this case and for spending the time that you have with what is a fairly extensive record. I'm Adam Lee. I represent Joan Kelly. This record in this case is large, as I said. It contains a whole lot of things, including a 2-day full termination hearing in front of the county commissioners. The recording of that was provided as part of the record. Plenty of subplots and plots and different statutes that don't necessarily relate to the Maine Human Rights Act. They relate to other potential causes of action, as well as issues dealing with the way that the county commission conducted themselves. That being the case, 10 minutes is not sufficient to give you all of that background. Thankfully, I don't think I need to in this case, because there were some fairly clear discussions that happened at the IRC in this case that to us quite clearly demonstrate sexual discrimination, disparate treatment, as well as whistleblower retaliation. At the IRC, the sheriff admitted that other male employees of the sheriff's department had been similarly insubordinate in the way that Ms. Kelly was alleged to have been, and they were not disciplined, much less even suggested to be terminated. The sheriff also admitted that he would have treated Joan differently if she were a man. If that's not disparate treatment, I don't understand what is. I don't know what better evidence one could produce of disparate treatment. The sheriff brushed off the insubordination of some of the male employees by, in particular, one male lieutenant of the department, by saying that the lieutenant was, quote, a military guy and just being passionate when he had argued with the sheriff, when he had so persistently argued with the sheriff that it went to his email. And as a result of his arguing consistently with the sheriff on his email was cut off for some amount of time. That same lieutenant admitted to Joan that he believed he would be punished, that he would be disciplined, and that he would be terminated. He was not. There was no disciplinary action suggested for that male lieutenant, who had behaved in what we believe is the same policy recommendations that were applied to Joan. The sheriff's actions and frankly his words at the IRC are pretty stark examples of sex discrimination, sexual stereotyping, and cognitive bias in application of what is expected for the way a man can behave in terms of their employer, in terms of their up the chain of command, versus how a woman is expected to behave in those same instances. Joan was recommended for termination by the sheriff. The sheriff said he could no longer continue to work with Joan anymore at the hearing. The county commissioners did not recommend, which was their only statutory authority, that she be terminated. As a consequence, the sheriff delayed bringing Joan back into the office. When he ultimately did bring her back into the office, he did so trying to make her a probationary employee, which would preclude, under county law, the ability for her to have a for cause portion, a due process hearing that she had in the first instance. And so essentially the sheriff, through the reemployment of Joan, attempted to make her a different type of employee whom he could terminate eventually. And so definitely Joan saw that as a fait accompli, believed coming back to the office would mean that she would be terminated because there would be additional findings of problems. Additionally, and concerningly, the investigator's report does not even address the allegations of whistleblower retaliation that are clearly outlined in the materials that were provided, clearly outlined in the record. Ms. Kelly had made complaints to the county commissioners, including all of the county commissioners in a public meeting, as well as to the county's HR official about the sheriff. Specifically, the event that she was complaining about was a crash by a sergeant of the department in a completely different county. As a result, that official ended up leaving their position, but there was a cover-up essentially that the sheriff had participated in and had actually altered some records, resulting in that sergeant being able to be paid out his employment benefits that he would have otherwise not been able to because the resignation date was changed by the sheriff in the resignation letter. All of this was matters that Joan had discussed specifically with the county commissioners, specifically with the HR representative. At the time of his attempted termination of Joan, the sheriff was aware of this. It was something that bothered him. There was testimony from the chief at the testimonial hearing, the termination hearing, that on several occasions the sheriff had asked the chief whether he could terminate Joan or stop her from actually attending these county commission hearings in the future. So it was obvious that this was something that bothered him. It was obviously something that he wanted to prevent in the future. Flash forward, after the termination hearing, after the county commissioners say, no, you can't terminate Joan for this, in his performance improvement plan, he included a couple of provisions. One of those provisions was to make her obtain permission from the sheriff's department before she could attend any future county commissioners meetings, and an explicit statement that said Joan must discontinue discussing outside of the sheriff's department any matters pertaining to business within the sheriff's department. So I won't get into the ways in which that might be a First Amendment violation, but certainly we think that the actions taken by the sheriff and the sheriff's department were meant to chill her speech as a consequence of her previously sharing information with the county commissioners and with the county writ large. So I would be happy to answer any questions you have, but I reserve the remainder of my time.
I just had a whole conversation with myself. Thank you, Mr. Lee. Just noting what time you have left. Commissioner questions for Mr. Lee at this time? Not seeing any at this time. You have about 3¼ minutes left when we come back to you. And I think that brings us to Miss Dietrich. Yeah.
Dietrich, but I'll answer to anything. And I apologize in advance. I'm not feeling well, so I'm going to do my best today.
Oh,
sorry.
Go ahead. I won't count your coughing time.
Okay. Thank you. Good morning, commissioners. I am here on behalf of the respondent. My name is attorney Amy Dietrich. By way of a little background in this case, on December 6th, 2019, while in the course of her employment as clerk, Ms. Kelly directly and publicly insulted the very top employee in her department, who I will call CW, due to her frustration over her perception that he was not addressing an impounded motor vehicle as quickly as she wanted. Ms. Kelly initiated this confrontation with this high-level employee by walking into a public common area, saying to him, quote, "Do you ever do anything?" End quote. These words were heard by at least one other employee in the office. CW then asked Ms. Kelly in reply if she was being sarcastic or disrespectful. When she indicated she was being serious, they went to meet in his office with another employee present as a witness. Ms. Kelly, as she was going into his office, told him to, quote, "bring it," end quote, meaning bring it on. She has, as Attorney Lee indicated in a subsequent termination hearing, admitted to saying these things. There is no dispute of fact about what she said during this meeting. During that meeting, when they were talking separately in CW's office, she also said that CW, again, the top employee in her department, does not deserve her respect, and that he was a toxic person in her agency. CW then thought about it over the weekend, met with her on Monday, and said that he was going to recommend that she be terminated to the county commissioners. She was then at that point on paid administrative leave. And it's an important point for the rest of the time period that I'll be discussing until she quit, she was on paid administrative leave. A formal hearing before the Respondents Board of Commissioners was held on 2 dates in January and February 2020. On February 18th, the commissioners met and issued their written decision, finding that although there was not just cause for termination, they did suggest that discipline was warranted because Ms. Kelly's behavior was found to have been, quote, "rude, impolite, contemptuous, demeaning, and provoking." Based on the testimony and evidence, the Respondents Commissioners recommended that CW's department implement an action plan for performance improvement so that Ms. Kelly could return to work and issue her a written reprimand. That's exactly what Respondent began to do. They set up a meeting to cover the disciplinary findings and talk about her onboarding, recommendations and procedures on March 19th, 2020. Prior to that meeting, Maine recorded its first confirmed case of COVID-19 and a civil state of emergency was declared by Governor Mills. Respondent remained open as a public agency, but the focus of the department went on responding to and adapting to the state of emergency and ensuring the safety of the public and Respondent's employees. Nevertheless, Respondent met with complainant on March 19th, 2020 to go over her job description, written discipline, and performance improvement plan, which I'll call a PIP, in contemplation of Ms. Kelly returning to work on March 30th, 2020. The written discipline included a 5-day suspension without pay and a 6-month probationary period, during which time Ms. Kelly was expected to demonstrate improvement in areas noted in the PIP. Now, Ms. Kelly has claimed in her objection to the investigator's report that the PIP was wholly unrelated to her admitted wrongdoing, but each of the areas of the PIP were structured to address issues with her employment that the termination hearing had revealed. At the commissioner's request, I can go over each bullet point from the performance improvement plan, but suffice to say they were tailored to ensure she was able to perform her position successfully when she returned to work and in response to information that came to light as a result of her hearing, primarily the discovery of how much work Ms. Kelly had been doing that was not part of her job. In the meeting on March 19th, Ms. Kelly quibbled with non-substantive minutia and had questions about some of the documents. And so the respondent's HR consultant agreed to clarify some of the phrasing in these documents. They then exchanged a dozen or more emails back and forth through March and all of April, based in part on confusion about which document each of them was editing, technological challenges from the HR consultant's computer crashing, and Ms. Kelly's repeated requests to edit and make minor grammatical and typo changes to documents. Ms. Kelly's return date with all of that back and forth that she participated in was set for May 18th, 2018, which was the first date everybody was available to go over her paperwork, give her time to go through procedures and come back on board with COVID-19 procedures. But on May 15th, she emailed her supervisor with even more questions and comments about the written discipline and PIP. As a result of this email, they pushed back her date to come in to May 21st so that everybody could go through that. Worth noting is that in the INR conference, Investigator Brindley asked Ms. Kelly if she thought that COVID-19 and the back and forth emails were the cause of her delay of her return to work. And Ms. Kelly said that she didn't think it should have been an issue because, quote, if people were competent, end quote, it would have been done right the first time. This is a telling statement because Ms. Kelly herself testified that she didn't believe there was something malicious about her delayed return to work. Just to review that respondents' employees were not as competent as herself. On May 21st, everyone met and Ms. Kelly's supervisor passed out packets. She signed everything, was given materials to go to work. Instead of getting to work 15 minutes later, she delivered a lengthy pre-written resignation letter that was inaccurate because she had written it presumably with her attorney prior to coming back to work. She had no intention of actually trying to come back to work and instead chose to sue the respondent. Responding quickly to a few points made by the complainant in her objection to the investigator's report, Ms. Kelly misleadingly misquotes CW when he was asked by Ms. Brindley about whether he would have treated Ms. Kelly differently if she were a man. He didn't say that he would have. What he said was that he had several negative interactions with Ms. Kelly before the December 6th incident and probably would have dealt with them earlier if she was a man, but he did not. And he went on to testify that he would have dealt with the December 6th outbursts the same way, whether she was a man or a woman. Similarly, the two males who Ms. Kelly cites as comparators to suggest that she was treated worse are like comparing apples to potatoes and not apples to apples. First, I'll note that Ms. Kelly has no firsthand knowledge of either of these incidents. She wasn't involved with them and is testifying merely based on scuttlebutt. And here she had it wrong. CW testified during the INR conference, but both of those incidences involved two people respectfully disagreeing with the sheriff and passionately just saying what they disagreed with him about, but that they were not disrespectful in the same obvious way that Ms. Kelly admitted to having been publicly towards CW. In addition, one of those individuals, who I will call CD, or the chief deputy, was essentially sort of a replacement for CW because when CW is absent, he acts in the same role by statute. So CW testified that he saw them as different because the role that CW plays is more of a peer rather than a subordinate. With respect to purported whistleblowing activities, CW didn't know that Ms. Kelly had participated in any interviews or made any allegations. Assuming that's true, he didn't testify that he actually knew about that during the INR conference. That's inaccurate from the complainant's presentation. It's simply untrue that he was aware she was involved, despite what Ms. Kelly has represented to the commissioners. Finally, as to her attendance at public meetings, CW and the respondent had no problem with Ms. Kelly doing so, as long as she punched out and her department was adequately staffed. That's it. There's no grand conspiracy, and all of the employees were obligated to follow the same policy, both men and women, once respondent became aware of the issue and revised its policy for all employees. Thank you.
You did a good job holding that off to the end. While she's coughing, any commissioner questions for Ms. Dietrich? Commissioner questions for Ms. Dietrich. Commissioner David.
Did she sign the employment improvement plan?
She did.
Why does she do that if she's alleging discrimination in it?
I certainly can't speak to Ms. Kelly's intention, but she signed the performance improvement plan on May 21st before delivering her pre-written resignation.
Oh, that's all the same day?
It is. It was all that same meeting. She came in, they onboarded her, she signed everything, and then she left the office and quit.
Has respondent shown comparisons with males that are pretty clearly different than the treatment of her, particularly this comment about the male that gets a pass because he's a military guy?
Yes, so that is in reference to I believe he's a sergeant or lieutenant, and the actual facts of that interaction, which were private behind closed doors. CW testified during the INR conference that contrary to what Ms. Kelly believed, because she was reporting based on scuttlebutt, that person never behaved in a disrespectful manner. CW said he viewed it as him being passionate and conveying his passion in a way that was not inappropriate, and gave him time to cool down, but it was not a similar incident such as what Ms. Kelly's outburst.
I can agree that the comment, do you do anything around here, or do you do anything, is disrespectful, but I just learned, it just became clear to me that that's the tip of a situation that she's complaining about that sounds like a serious complaint, not taking action about an officer involved vehicle accident and sweeping it under the rug. Isn't that a fair characterization of that?
No, no, and thank you for letting me clarify that. So Ms. Kelly's outburst about do you ever do anything was about an entirely separate incident. So Ms. Kelly had been trying to deal with some sort of impounded car and the cost for dealing with that impounded car. And she had her outburst about that, which is not a comment about anything that was illegal or unsafe. And she has not alleged in her complaint before the Maine Human Rights Commission that her comment about do you do anything was related to a safety or illegality issue. Ms. Kelly's meeting with the respondent's HR consultant about a completely separate investigation, which again, she had no firsthand knowledge of and did not actually shed light on anything about, was entirely separate and occurred at least a few weeks separate. And I will say again that CW said during the INR conference, he had no idea that she had actually met and was talking with anybody about that incident.
Any additional commissioner questions for Ms. Dietrich? Seeing none at this time, Ms. Dietrich, you'll have about 1 3/4 minutes when we come back to you.
Thank you.
Back to Mr. Lee with 3 1/4 minutes.
Thank you. I'll just pick up there sort of at where we ended. The question that she asked, do you ever do anything, was not isolated to one event dealing with the impoundment of a vehicle. It did deal with many of the issues that she had been talking about within the department, including the one dealing with the sheriff and the accident that had occurred outside of the county, and one with which she had been talking to county commissioners. So I wouldn't reduce that statement to just the impoundment of the vehicle, which was something that was of concern to her because it dealt with the sheriff not communicating effectively with the public that was seeking to discuss a specific issue dealing with the impoundment of a car with the sheriff, and the sheriff continuously telling her that he should not be the one communicating it, that she should be communicating it, despite her trying several different times. I'd also like to, this is an instance in which if I had the video queued up or the audio queued up at the termination hearing, we could directly impeach a statement that the sheriff made at the IRC. According to Attorney Dietrich, what he said was that he had no idea that she had been going to county commissioners meetings. And that is just simply false based on the testimony of the chief deputy at the termination hearing, in which he said he had been asked several times by the sheriff whether or not they could prevent Joan from going to county commissioners meetings based on his knowledge that she had been going to county commissioners meetings. It's in the record because it's in the recording. I understand that that's a 2-day recording that we can't play here, but it's a highly relevant piece of evidence when it comes to the whistleblower portion of the case. I'd also like to go back to the idea that when the other 2 male individuals were talking, they were being passionate. That is the definition of cognitive bias. These men were being passionate because of the perception of the sheriff, which is based on a sexually discriminatory way that he believes that men can talk to him versus the way that women can talk to him. There was no decipherable difference between the ways that these individuals spoke to him. It was that a man was doing it versus what a woman was doing it. That's the apples to potatoes comparison. He's fine with all of the male lieutenants, deputies, all of those individuals reaching back at him. The policies that were applied are supposed to apply to all staff because it's a chain of command issue. That includes sheriff's deputies, that includes lieutenants, it includes as well the chief deputy, who is someone who is subordinate to the sheriff. And so, frankly, the notion that these are separable people is highlighted by the fact that none of the people who are in the position of deputy, chief deputy, sheriff, any of the individuals who are allowed to talk to the sheriff this way are women. They're all men. All of the subordinate staff who are subject to these rules, evidently, are women. I think that's the dictionary definition of disparate treatment. Thank you.
That's your time. Any commissioner questions for Mr. Lee? Commissioner questions for Mr. Lee? I am not seeing any. Thank you, Mr. Lee. So now we're back to Ms. Dietrich, and you have 1 3/4 minutes.
Thank you. I just want to follow up on two things that Attorney Lee just said. The first being that I had represented that the sheriff had CW had no idea that Joan Kelly was attending commissioner meetings. That's not what I said, or certainly not what I intended to say. What I was saying is that he didn't know that she was meeting with the HR consultant. He was aware from time to time when he went to commissioner meetings that she might be there as well. And so I appreciate the ability to clarify that. Secondly, it's simply just not true that all of the subordinate staff are women. There is an IT person who is a male, and all of the policies that applied to Ms. Kelly applied equally to both men and women. And there were both men and women in that department. So, for example, with respect to the need to get permission to leave work in the middle of the day, if you want to go to a medical appointment, a commissioner's meeting, to go sit in your car, that applied equally to all of the male and female employees of the respondent, including Ms. Kelly, if she had chosen to stay at work. I have nothing else to say and appreciate the commissioner's time.
Any commissioner questions for Ms. Dietrich? Seeing none. Thank you, Ms. Dietrich. And now we are looking to the investigator, Alex. Oh, Commissioner Dusan, were you just sitting up because you suddenly remembered a question? You're muted.
It was triggered by something Attorney Dietrich just said. The PIP, did it include a request not to attend? Did it include a promise not to attend commission meetings?
No, Commissioner, it did not.
Okay, thank you.
Any other questions for Ms. Dietrich? Okay, to you, Alex.
Thank you, Amy. Good morning, everyone. My name is Alex Brindley. I was the investigator assigned to this case. If you see any movement in the background, it's because I'm at my cube. I apologize for that. So there's just one thing that I really want to discuss now. I think everything else was covered. There was some dispute over whether the outburst on December 6th was just due to the impounding car, and I believe that is the fact. I'm reviewing my notes that I took during the IRC, and there's no reference at all to any other prior issues that she might have had with sheriff. So I believe the major issue regarding the outburst was in fact the impounded car. And there was some differences, disputes as to whether complainant was treated differently because of her sex, which I would disagree with. I think really the crux of the matter here is the fact that complainant was disrespectful to sheriff in a public space, whereas the other two individuals were not. There might also have some hierarchy things to deal with because the other two individuals were a lieutenant and a chief respectively, or chief deputy. But I believe that's everything that I wanted to discuss, but I am open to questions.
Any questions, commissioner questions for the investigator? Commissioner Dusan.
I just want to make sure I understand your distinction between the disputes amongst 3 different employees and the sheriff. You said that the instant dispute was not in public, and I think I read into that based on my review of the file and stuff, that those were meetings behind closed doors.
Correct.
Yeah. Okay.
Yeah, based on the
wanted to
notes
make
that I
sure.
have here, the other 2 meetings, or the 2 incidents with the other coworkers occurred behind closed doors.
Thank you very much.
Commissioner David.
Is December 6, 2019, the date of that statement in public? Do you do anything around here?
Yes.
Or, okay. In your conclusory paragraph, you say complainant failed to provide evidence to support her belief that her discipline and its severity were because of her sex. Isn't the comparison with the other officers and the lack of resulting in a employment improvement plan and discipline, isn't that an indication of disparate treatment?
Well, certainly she meets her prima facie case. However, the respondent here, let's see, the respondent here did provide a non-discriminatory reason for the adverse job action, namely her insubordination, the comments that she had made.
Why is that insubordination, Alex?
Well, I might not be
disrespectful, but it's
yes.
Okay.
Yes, I might be using that word incorrectly, but it was disrespectful.
Okay.
Any other questions for the investigator? Seeing none. Thank you, Alex.
Thank you.
So commissioners, you've heard from the parties and the investigator. At this time, we would be looking for a motion or motions. The recommendation given to you proposes a finding of no reasonable grounds on both sex and whistleblower and MHRA retaliation. If you want to separate those out, you can, or you can vote on it as is.
Sorry, muted. I will move that we accept the recommendation of the investigator that there are no reasonable grounds to believe that respondent discriminated against complainant on the basis of sex or retaliated against her based on WPA and/or MHRA protected activity, and the complaint should be dismissed in accordance with the act.
Is there a second?
I'd second that.
So it's been moved and seconded. Is there any discussion? I do not see any, although Commissioner Doosan looks, nope, okay. So the motion is to find no reasonable grounds on both sex and retaliation. If you say yes, you are in agreement. Commissioner Whitworth?
Yes.
Commissioner David?
Yes.
Commissioner Doosan?
No.
Commissioner O'Brien?
Yes.
So by a vote of 3-1, the findings are no reasonable grounds, and the commission will send a letter to parties and council confirming that, and thank you for your participation.
Our next case.
And actually, hold on, if you don't mind, I just want to check. I think we have someone on the line that is for not this hearing, but the next one, but I just want to check that. The person whose phone number ends in 219, is that Sheila Michaud? If you can unmute yourself. I actually don't know what button you push to unmute yourself.
*6.
*6. Ms. Michaud, is that you? Is that Sheila Michaud? If you are speaking, we cannot hear you. And we still cannot hear you. Okay, I'm gonna mute you again and ask my office to call you because your case is not this case, but the next one. And we just want to make sure we have you on the line. Right, thank you for letting me check that.
Okay, so our next case, E20-0242, Benjamin Landry v. Town of Scarborough. This is a reasonable grounds recommendation. Is there anybody here for the respondent?
Yes, Commissioners, this is Mark Franco at Drummond Woodsum for the respondent, Town of Scarborough.
Go ahead, Mark. I mean, Attorney Franco, sorry.
Thank you. Thank you. Thank you all. This is a case in which the complainant, Officer Landry, and the respondent, the town of Scarborough, had a interactive dialogue concerning Patrolman Landry's request for a certain type of vest over the course of an extended period of time. And what ended up occurring was that the town had provided a couple of alternatives to Officer Landry early on in the process, neither of which met with his satisfaction. He basically decided not to accept the accommodations. So after that, the town, at Mr. Landry's request, actually worked with the manufacturer of the vest that he wanted and ordered it and actually obtained it. The problem with this case really was that the amount of time that was involved from the time that the vest was ordered to the time that it was actually delivered. There is a factual error in the findings in that I think it said at the top of page 3, it says on or about March 2nd, 2021, the vest that best suited complainant's need was ordered by respondent. There was no time frame for when the vest would be received and outfitted. What actually happened was that the order was placed prior to September of 2020. And I think Officer Landy would agree that there's email communication between the manufacturer and the city prior to September of 2020 in which the vest was ordered. And there is actually in the record a bunch of emails between the manufacturer and the town concerning the delays in because they basically had to fabricate a whole new vest to meet Officer Landry's request. So there's actually an email included in the record dated June 26, 2020, saying we would like to expedite the purchase of the vest and the requested customizations. And that was copied to Officer Landry. It's also not true in the record where it says the communications between the manufacturer and the city or the town were not made known to Officer Landry. I think the reference is that it was not made clear to the complainant where the order stood. The record is replete with emails between the manufacturer and the town concerning the status of the order, and Patrolman Landry is included on all the emails. In fact, he had direct communications with the manufacturer to find out where the vest was. So it's true that it wasn't delivered. So it was ordered, before September, sometime in the August-September period of 2020, and it was actually delivered in June of 2021 after the records closed. I find it a little bit ironic in that Mr. Landry's complaint was actually too late. It was filed after the 300 days, yet there seems to be some sort of criticism of the fact that, after the evidence closes, we informed the commission that the vest was actually delivered to Mr. Landry. I mean, we had no control over the date that it was delivered. So as a courtesy to the investigator, I wanted to make sure that it was known that it was in fact delivered and everything was fine. And yet with all of that said, it was still determined that discrimination occurred. And right in the response to the complaint, I challenged the issue of disability. I understand that the Maine Human Rights Act and the ADA is very broad in terms of what the definition of disability is. We have one medical record in file, reference the fact that Officer Landry has a degenerative disc disease in his back, which most people do at a certain age. So we do have that, and whether or not degenerative disc disease translates equally to disability, I don't think that that's an accurate statement. There's a sort of a footnote in the record that says that he it substantially limits one or more of his life activities and significantly impairs his physical health. I'm not sure that is in the record, frankly. So I did challenge that point. But I think the most important point for the commission is that, the city or the town did everything that it was required to do and more over in terms of the interactive dialogue and working with Officer Landry and trying to meet his requests and his needs. They didn't ignore him. There was constant communication. What happened was that they had to actually order and pay for and customize a vest to meet his desires. There were other alternatives that were proposed by the city or the town, and they were rejected. So I guess, does it boil down to, you have to give the complainant exactly what they want in order to meet the definition of reasonable accommodation? Or do you work with someone in hopes of trying to resolve the issue? And ultimately, in this case, they did, in fact, give him exactly what he wanted. It just took longer than everyone, hoped it would. It wasn't anyone's fault. I mean, the manufacturer had to devise a new vest. So the investigator in this case basically said that the city or the town should have basically changed this policy, changed its uniform policy. Now, keep in mind that this case is all in the context of all of these issues nationwide about police in terms of how they respond to events and how they present and how they are being, treating people unfairly and things like that. This is the vest that Officer Landy wants is a tactical SWAT vest. And the town had a policy. They didn't want to have police officers have this appearance as soon as they walked up to someone that they stopped on the side of the street, that they had this tactical SWAT vest on. So the city made a decision not to allow its uniformed personnel to have that type of vest on. And so I guess if the commission believes that the city was required as a matter of law to change its policy to allow a tactical SWAT vest, I guess that's the commissioner's decision. That's the Maine Human Rights Commission's decision that under these circumstances, you actually have to change a uniform policy to one that actually strikes more fear into the citizenry than keeps them calm. So basically, it's our position that the city and the town did everything that it was required to do under the law, under the Maine Human Rights Act, work with Officer Landry, tried to make it so that he could work, patrol, and ultimately did satisfy his request. And yet the town in this case is being branded as a town that discriminates against its patrolmen. We think that the reasonable grounds finding was misplaced under the facts and circumstances of this case. Thank you.
Thank you, Mr. Franco. Commissioner, questions for Mr. Franco? Not. Oh, Commissioner David? Yes.
Is he working as an officer with for the department with the new vest?
Yes, as far as I know.
That's all.
Any other commissioner questions for Mr. Franco? Not seeing any. So Mr. Franco, you'll have about a minute and a half when we come back to you.
Thank you.
Mr. Landry?
Yes, thank you.
You have 10 minutes.
I would rebut the respondent's argument by saying that work is a major life activity. And noted in the investigator's report, I'm required to wear a gun belt on a daily basis, which contains multiple items. While wearing that gun belt, I experienced significant pain and discomfort while at work, which I attribute to that gun belt. I notice quite a bit of relief at the end of my shift when I take that gun belt off, days off, vacation days. Also while at work, wearing my gun belt in moments of pain. Officers comment on my posture when I walk, that I walk like an old man, or that I've defecated my pants. The respondent stated in their rebuttal to the investigator's report that I've never missed work due to my condition. However, it's noted in my initial complaint that I have. I've provided the respondent with medical documentation that they have requested from me. I've tried to be as open with them as possible about my condition. In January of 2018, the respondent was given a note from my primary care requesting for medical reasons an external load-bearing vest carrier due to an underlying medical condition. As noted also in my initial complaint, on 5/4/18, a representative of the respondent, a supervisor, accompanied me to a doctor's appointment of my treating MO at the time. For that appointment, I drove a marked patrol car and was in full uniform. At that time, there were 2 vest options that we were exploring. One, I had already been allowed to trial. The second, the respondent was thinking about allowing me to trial. They were able to be at the appointment with me and my treating doctor at the time. The doctor was able to look at the different options: vest carrier, my regular uniform, me seated in the cruiser. They were able to discuss which option would be the most ergonomic. I believe that at that time, that was the respondent's opportunity to seek any clarification on my condition and the cause of my back pain, and to obtain my doctor's medical opinion on my condition and pain and comfort. It's also noted in my yearly evaluations. We have a physical fitness portion on our evaluation that I am medically excused from taking a physical fitness test. The respondent has also claimed that they have accommodated my request. It wasn't until after the closing of evidence to the commission that the vest was actually given to me and allowed for me to be worn. I do wear an external load-bearing vest carrier at this time. I believe that there was sufficient evidence noted in the investigator's report and documentation that I've submitted to show that the respondent failed to modify its uniform policy and accommodation request. The accommodation at that time was a black, the model is a Traverse vest carrier, which was purchased out of my yearly clothing allowance. We receive $1,000 a year to purchase clothing and equipment that we need for our jobs. That was paid for out of my clothing allowance, so it did not cause any undue burden for the respondent. The respondent's uniform policy allows for modifications for other health issues, which require a doctor's note. However, they refuse to make any modification to their policy for my request. As noted in my initial complaint in January of 2018, a representative of the respondent told me that if he allowed me to wear an external carrier, it would open the door for everyone else with back pain to wear one. And I believe that from the onset, there was no indication that they were going to allow me to wear that. There was oftentimes dialogue between myself and the respondent by email. I wasn't always necessarily kept in the loop of what was going on. There would be large gaps of time between email correspondence. Attorney Franco today stated that I had direct contact with the manufacturer. That is not the case. I had direct contact with our uniform supplier, not the company that manufactures the vest. They're a very large company. Also, our uniforms, this vest that I was seeking as a reasonable accommodation to help alleviate my back pain is worn by other members of our department and is allowed to be worn by other members of our department. It was just not allowed for me as a patrol officer to wear. Those members are not tactical police units. They're not SWAT team members, as Attorney Franco is trying to say that this vest is. It's not a SWAT vest. Our SWAT officers wear a completely different vest. I also submitted as evidence to the commission a list from our uniform supplier of agencies that wear the vest that I was asking for. And in that list is our agency and our town specifically. EMS providers, rescue providers in our town are allowed to wear this vest. Detectives, members of our special enforcement team within our agency are allowed to wear this vest. We also have a non-SWOR behavioral health specialist that is also allowed to wear this type of vest. Attorney Franco also stated that the vest had to be manufactured to my standards. I don't believe that that is the case. I think it's evident through the emails that have been submitted that the back and forth between myself and the respondent was to find a vest carrier option that they felt best fit what their vision was for our uniform appearance, not necessarily what would be the quickest and easiest option to make sure that I was not in pain. I tried different vest carrier options. Some of them, one of in particular that the respondent asked me to trial. I spoke in detail with our uniform supplier, and they advised me that it was doomed from the start to fail, that another agency had tried that exact same vest and had told me the issues that the cloth material would basically rip very prematurely because it was not designed to carry the weight from one's gun belt. So I tried very hard to try these different options and work with the respondent in finding something that would both alleviate my pain and also meet their criteria for their uniform appearance. That's all I have at this time. Thank you.
Thank you. Commissioner questions for Mr. Landry? Commissioner O'Brien? You're muted.
I apologize. To your last statement that you tried to find them, are you disputing that the town also tried to accommodate to fit both? I mean, I guess I'm confused about that.
So initially in 2018, when I submitted my initial doctor's note to the respondent, I asked to trial an external load-bearing vest carrier. As noted in my initial complaint, I had talked to other officers. There's studies out there that show that can help alleviate back pain and problems. So I asked the respondent to try that because I was experiencing significant back pain at that time due to my condition and my gun belt. And that's when the respondent advised me that they would, if they allowed me to wear one, then that would kind of open the door for everyone else with back pain to wear one. So I talked to them about trialing vest carrier, one that was already being worn by a number of detectives and other members of our agency. And they then allowed me to order it, but did not allow me to trial it right off. They had an option that kind of met their uniform appearance a little bit better than the vest that I was asking to try.
Any other, Commissioner David?
Isn't it appropriate, Officer Landry, for them to set a uniform policy and to make a determination as to whether it's too militaristic for a public-facing officer?
It is. The problem that I struggled with is that, well, I'm a patrol officer, but you're allowing the detectives and other members of our agency to wear the exact same vest, but I'm not allowed to wear it. And those officers don't wear a gun belt on a daily basis. They do not have, to my knowledge, any medical conditions.
They don't wear a gun belt. They don't wear a gun belt on a daily basis.
Correct.
So they're
Correct.
not
Only patrol officers do on a daily basis.
And they tried. It seemed to me you said that they didn't give you other options. They gave you several other choices that you tried over the year, right? Oh,
they did give other options. Yes. Yes. I'm sorry if I misspoke on that, but there were other options posed by the respondent for me to trial. I did trial. One of those options, it involved wearing suspenders under the shirt, and while it did give me some back pain relief, it ended up causing me shoulder pain, and which addition to my back pain, I stopped that trial and documented my pain while trialing that.
And are you now using the new vest, and is that accommodating your disability?
Yeah.
If you could, if I would, I know it's in the record that the town has provided the vest. I guess I would ask that we not talk past that about what's happening currently, because it's not in the record.
Okay, yeah, I mean, it's appropriate not to talk with the respondent about further than that, but I am going to have a question for counsel as to why we can't reopen the record. We make accommodations all the time, but that's a different issue.
Yeah, I'm done with my time. So,
Commissioner Doosan?
Thank you, Officer Landry. I want to know if the vest that was that has now been delivered, is that the same as the one you originally requested? And what if not? Yeah, is it the same one you originally requested?
it is not.
Is it the same one worn by others in the department who are not wearing a gun belt?
No, it is not the same vest. The vest that the other members wear in black is the one that I asked to trial and was allowed to trial for 2 weeks. And then the respondent told me, no, I couldn't wear it after I told them that helped my back pain and alleviated things. They told me, no, I wasn't allowed to wear it any further because, oh, sorry, go ahead.
Is the only difference that it is that it is black?
No. So my new vest, the one that the respondent has given to me after the end of evidence submitted for this case, is gray. There's also some modifications to it to make it look more like our existing uniform shirt. There's pockets sewn onto it.
Yeah, I don't want you to go too much beyond what Director Sneerson has suggested. I just wanted to understand. Okay, I'll leave it at that.
I'm not trying to stop commissioners from asking about the vest that was provided. I think that's a different question than how is that working for you now? Because Officer Landry may have a claim about this time period that is not posed here and that's not part of this case.
So let me make sure I understand that when exactly, so the complaint was in January 2018. Can someone remind me, if it's inappropriate for me to ask Mr. Landry, the close of evidence, what month or date was that? And so the time in between there, Mr. Landry was wearing the gun belt, and throughout that time, absent time when he was using a alternative, trialing an alternative offered by the respondent, he was consistently reporting the same pain. The items in that time were not alleviating the pain. I think I understood Mr. Landry to say that, and I just wanted to be sure.
Yes, I trialed a vest that I trialed it, I believe, for a couple months that helped alleviate some back pain. I developed shoulder pain, so I had to stop wearing that because now I had pain in both my back and shoulder. And then I went back to my gun belt and I wore that until this vest had came in.
And you provided medical evidence of the time period that you used the alternative, and then going back to the just the gun belt. I think I heard you say that as well, that was part of the record.
Medical evidence?
Mm-hmm.
No, I didn't submit any medical evidence showing that I was wearing those vests. The evidence that I have was documentation that the respondent went to a doctor's appointment with me to look at the different vest carrier options and was able to talk to my treating doctor.
Okay, thank you. Thank you.
Thank
very
you.
much.
Any additional commissioner questions? Commissioner David?
I didn't hear an answer to Commissioner Dusant's question about when the date of the close of evidence as compared to the date of the provision of the
Because
vest.
it's probably easier for me to answer this than for Mr. Landry to search for it. Check out
Thank you.
footnote 2 in your report.
Okay, thank you.
Any additional commissioner questions for Mr. Landry? Not seeing any. Commissioner David, are you all set?
Yes.
Okay, so I believe we've now heard from the parties, right? We've gone back and forth and back and forth. No, we haven't gone back. Mr. Franco, did I already come back to you? Okay, so you have, sorry, I lose track sometimes. You have 1.5 minutes.
Thank you. I don't need a minute and a half. I do stand corrected. Officer Landry is correct that he was in contact with the supplier, not the manufacturer. We went through this supplier called Admiral, and they were the ones that coordinated it with the manufacturer. We experienced a lot of frustration with the supplier in terms of trying to get this right, trying to get it, the right type of vest. And the delay was not our doing. It was all between the supplier and the manufacturer. And as far as this issue of other members of the organization wearing the other vest, that may be true, but again, think about the rationale behind the appearance policy. These are patrol officers who are responding to traffic accidents, to arrests, to suspected drug issues, and more importantly, just regular traffic stops. And when there's this sort of intimidation factor with a patrol officer with a gun belt and what we would consider to be a ballistic vest walking up in the rearview mirror of someone who's that's different than some of these other people who don't wear guns and they wear the vest, but they don't wear the gun. So I think that there's a causal nexus and a reasonable rationale between allowing some people who don't respond to patrol-like situations in the general public versus others who don't
Mr.
wear the
Franco.
belt, the guns.
Mr. Franco.
So, yeah, thank you.
Yeah. Commissioner Dusant, did you have a question?
So defer my question to someone else if it's not appropriate for me to ask Mr. Franco. The time period here we're talking about for the respondent who the parties agree has a disability that is exacerbated by the wearing of a particular piece of equipment. There's a lengthy negotiation over how to accommodate there's a lengthy back and forth interactive process over how to change the equipment in order to relieve the pain that is caused by the disability. And that period is over 2 years, during which the officer is wearing the gun belt and experiencing the pain that we're discussing, or experiencing the results from the disability that we're discussing. Am I misreading something here in the fact pattern?
Well, it depends on when you define the complaint. The complaint wasn't filed until June of 2020. There was an interactive process that had been going on since 2018. And there was, in 2019, the city, the town started working with, we gave him a couple of other options and he refused to use those. And then in 2019, he began communicating through an attorney And, in 2019, that's when we started working with the manufacturer to get the vest that he actually, that best suited his needs. And we ordered it in September or August of 2020. So I don't know if that answers your question, but this case has taken a long time to get through the process. And by the way, we have one medical record in this case, and it's dated October 27th, 2014. That's the only record we have.
Thank you. I that's not quite outside of what I asked. I'm going to stop there. I may have a clarification question from the investigator or commission counsel. Thank you, Mr. Franco.
Any other commissioner questions for Mr. Franco? Not seeing any. Thank you, Mr. Franco. Mr. Landry, you have 2.5 minutes. You're muted. Yep. There you go.
Sorry about that. Again, the only thing that I would add is Attorney Franco stated that the vest that was best to suit my needs. That's not the case. The vest that best suited my needs was the vest that alleviated my pain. And that was the one that I trialed that was in black. It just didn't suit their perception or idea of what a patrol officer should look like. And so therefore they denied me to wear that vest. It wasn't until years later that I discovered that they made that same vest in gray, which closely matches our uniform shirt. And I brought that to the attention of the respondent, and that's what started the ball rolling towards me getting that vest in gray. So there was a significant time in which I wore that gun belt, experiencing pain while at work. When that black vest was bought, paid for, and was sitting in my locker. However, I was not allowed to wear that. I'd also add that, again, I've supplied a list of agencies that our uniform supplier supplies that exact same black vest carrier to. Many of those agencies are surrounding police departments that we work with. So, to say that by not allowing me to wear that and in the public perception aspect of things, I find hard to believe when agencies surrounding us wear that exact same vest. Nothing further. Thank you.
Any follow-up questions for Mr. Landry from commissioners? Mr. David?
Do you claim what you just said was you're making an argument that I don't think there's evidence for about other departments surrounding Scarborough? Do you claim that that there was any uneven application of the policy as being applied to other patrol officers?
No, not within our agency. No, I was simply bringing up the fact that our uniform supplier supplies surrounding agencies with the carrier that I requested, trialed, and was denied to wear.
And is that to say that Scarborough was didn't have the right information, or ignored it, or wasn't genuinely working to accommodate you?
What I'm saying is the town knew that when I made that request, and when that trial and me asking to wear that black vest carrier was denied, the town knew that was in fact the case, that other agencies wore that exact same carrier, as well as other members of our department.
Any other commissioner questions for Mr. Landry? Seeing none. Thank you, Mr. Landry. To the investigator, Ms. Thompson-Crossman.
Yes. So again, I was not the investigator assigned to this case, but I did write the report. This was fairly straightforward. Complainant requested a vest to deal with the pain that he experienced, not just at work, but with major life functions that we recognize, such as sitting, standing, walking, mobility. So he requested assistance with his pain. He was given 2 options to trial. One, he was told wouldn't work at all. He did try the suspenders. He tried them for the period of time that respondent asked him to try them. They did not provide him with significant relief. He then requested to trial a vest, a load-bearing vest in the summer of 2018. He trialed that vest for the period of time that he was directed to trial it for. It worked. It relieved his pain. He informed respondent that that vest relieved his pain. Respondent would not allow him to use that vest. They then engaged in a 2-year-long dialogue. For sure, there was conversation about what would work, how to make that work, but complainant already knew what worked and had the vest in his possession that would work. He had paid for it out of his clothing allowance. And the argument that respondent makes about the uniform policy itself says that exceptions can be made for medical reasons. They had a medical reason. They knew what would work. And yet complainant was not allowed to wear the vest that alleviated the symptoms of his disability. So I'm happy to answer any questions that you have.
Thank you. Commissioner, questions for the investigator? Commissioner David?
Kit, at the beginning of the report, you said you did write the report, although you're not the investigating investigator. In paragraph 2, you say you put community policing and you put militaristic in quotes, air quotes, to suggest that they're not correct, or to suggest that they're being misused. I mean, you're diminishing the importance of the policy, are you not?
I'm sorry, Commissioner David, I'm just trying to find, I see. No, I believe that's indicating that I'm quoting respondent's uniform policy.
That in what respect?
I'm quoting community policing is in their uniform policy, and 2 militaristic was in their response to complainant requesting to wear that vest.
Right. So why is militaristic in quotes?
Because she is, sorry, Kit, because they are, I'm all worked up. They are quoting the respondent.
Yeah.
We
So
would do
there are
that in any instance where we were
quotation
quoting the
marks.
respondent.
Okay, and you don't agree that that vest was too militaristic?
I don't agree that that outweighs complainant's right to an accommodation that alleviates the symptoms of his disability.
Well,
I understand the concern that respondent has in that instance. There are other members of the police department, generally not patrol officers. There are other members who wear that vest in black. I understand respondent's concerns, but I did not find that they outweighed complainant's need to not be in constant pain while he was working.
I think we're second guessing the policy, and that diminishes the importance of the policy, which I think is vitally important. The forward facing over militaristic appearance of police, I think, is a very valid issue, and not one that we need to second guess. And you're saying that you think this should be an exception, this type of vest.
I believe sorry, I'm jumping in. I believe what's being discussed is whether or not, no one's questioning that it's a fine policy in general, but the point of reasonable accommodations is to make an accommodation to a generally applicable policy that is necessary to allow an individual with a disability to do their job. And that's what was being asked. The policy itself says there can be exceptions made for medical reasons. No one's suggesting the policy is bad or it should be thrown in the trash. Everyone agrees with that notion about forward-facing police officers. The issue is whether or not an exception should have been made here to allow this police officer to do his job, whether that would have been reasonable.
And as long as I have your attention, Barbara, why can't we reopen the record to deal with the vest that's provided?
No one has made any claims about the vest that's been provided. I don't know.
Landry just did. He said it works and he's wearing it.
He did not say that.
Doesn't, well, he said that the vest that he has relieves his pain, I believe, but we deal with cases that address prior discrimination all the time. The fact that discrimination, whether or not in this case, but generally, the fact that discrimination has been alleviated does not mean that it didn't happen. We decide cases where respondents have taken forward-face action going forward, but we can still look at what happened and whether that was discriminatory. No one's saying that this respondent is bad. They're saying that this happened. Is it discriminatory?
And purely with respect to the timeline, we have a mandate to complete investigations within 2 years. We're up against that deadline. This case has taken far longer than we would have liked for an ongoing employee. We have a requirement by statute to complete our investigation. Whenever there's an ongoing situation, if someone has another claim that accrues during our investigation, we ask them to file a subsequent complaint. We cannot violate the 2-year requirement to complete our investigation, which is what we would have to do here by reopening the investigation. Additional questions for the investigator? Commissioner Doosan?
Lots of times my questions are about trying to paraphrase what's going on in my head to make sure I'm not off on a side or chasing a shiny bauble in my analysis of how I might vote on the recommendation. What is paramount in my head at this point, and I want to double check with the investigator on this matter, is what we're dealing with here is a reasonable accommodation case, and the arguments back and forth are as to whether there was a reasonable interactive process, albeit it was a long time. There was an interactive process in the report. It acknowledges that both parties were fully engaged in that. In the end, the respondent did not actually provide a piece of equipment that met the discussion, the interactive process steps until after close of the case. And though I certainly have very strong feelings about the uniform policy, that's not what we are reviewing here. We are reviewing whether an employee with a disability who requested an accommodation received a reasonable accommodation or received a reasonable response to that request. And in this case, the investigator has concluded there are reasonable grounds to believe that the town discriminated against Mr. Landry in his employment in relation to the response to his request for reasonable accommodation of his disability. Am I off in the bullywag somewhere? It's very attractive for me to think about the uniform policy. I certainly understand the rationale behind it, but in this case, we have an employee with a documented disability who is experiencing pain as a result of equipment that exacerbates the disability. And I think it's pretty straightforward.
Yeah, I don't think you're off course. The only thing I would add is that during the 2 years that they were having a dialogue back and forth, they had a solution that worked. it was in complainant's possession, and he wasn't allowed to use it.
And the delay was not out of some out of some animus. It was the respondent's genuinely motivated attempt to find an accommodation other than the vest that was in the complainant's hands that would also meet the uniform policy issues.
That's correct. There are many emails in the record going back and forth about not just like the color of the vest, but also things like, well, does the vest have a chest pocket? And what about this piping on the collar? And what about, and so at some point that started to seem like, well, we know there is something that works and complainant has it, and maybe complainant could use it while we work out the details of this vest with the pockets and the piping.
I think I'm good. Thank you very much. That helps me make sure I'm got a clear thinking on this.
Commissioner David?
Kate, you just said that he had the vest and he wasn't allowed to use it. Was the reason, the stated reason was that it violated the policy in terms of its appearance to the public?
Yeah, it was the what I was quoting about it being too militaristic is the response the complainant received as to why he couldn't wear that vest.
Okay, that seems to implicate the policy as being on trial.
Nothing is on trial here, Commissioner.
The policy comes into question because the policy itself allows for exemptions for a medical condition. And that's what complainant was requesting as a reasonable accommodation, was a modification to the policy due to a medical reason. So I certainly am not, as the investigator who wrote the report, I certainly am not questioning respondents' uniform policy as a whole or the value of community policing and not having a militaristic look to the police officers. But the policy allows for an exemption for a medical condition, and that is what complainant requested as a reasonable accommodation. And so the analysis is, was his request reasonable? Was it an undue burden for respondent? And as you've read the report, it didn't seem like an undue burden, and certainly not after that length of time.
Any additional questions for the investigator? Seeing none, thank you, Kit. Thank you to the parties and counsel. So commissioners, you have heard from the parties and counsel and investigator. You have one proposed finding. So we'd be looking for a motion.
Do I need to be recognized first?
Not really, no, but okay, Commissioner Dusson.
Who is that strange woman with her hand up? I will move that we approve the recommended finding that there are reasonable grounds to believe that the town of Scarborough discriminated against Benjamin Landry in employment on the basis of disability, denial of a reasonable accommodation, and conciliation should be attempted in keeping with 5 MRSA section 4612 sub 3.
Is there a second?
Second.
Thank you. Commissioner Whitworth seconded. So it's been moved and seconded to find reasonable grounds to believe that complainant was subjected to unlawful and discrimination on the basis of disability. Is there any discussion? More discussion. Commissioner O'Brien.
Just so before I vote, being the very junior member of this, it bothers me that it's so clear cut to me. But I think I agree with Commissioner David. I'm not sure where he's going to go, but to me, this I don't think this reasonable ground. So that's how I'll vote.
Any other discussion? Seeing none. The motion is to find reasonable grounds to believe that respondent discriminated against complainant on the basis of disability with denial of a reasonable accommodation. If you say yes, you are in agreement with the reasonable grounds finding. Commissioner Whitworth,
Yes.
Commissioner David.
Yes.
Commissioner David, did you mean to vote yes, you're in favor of a reasonable grounds finding?
Yeah,
okay.
Commissioner Doosan convinced me.
Oh,
Yes.
okay.
And
Just wanted to
Commissioner,
check.
Commissioner O'Brien is correct that she's surprised, but I didn't think that was worthy of discussion.
Okay, I just
find
wanted to
it-
make sure.
I find it a close case, and I'm hearing the arguments, and I know what I'm doing
Okay, just wanted to check.
on rare
Commissioner,
occasions.
Commissioner, on many occasions. Commissioner Doosan,
Yes.
Commissioner O'Brien.
No,
Okay, so I believe the vote is 3 in favor of a reasonable grounds finding and 1 opposed to a reasonable grounds finding. Is that accurate? Yes, okay. So with that, the commission will send a letter to both parties and council confirming that finding and asking the parties about post-cause conciliation. Thank you both. I want to thank the parties for doing really great presentations today. As you can tell, this is a really tough case for the commissioners. So thank you for being here and participating.
Before we move on to the next case, Deb, could we have 5 minutes? The next one is also mine.
Yes.
Yes,
Thanks.
okay, so 5 minutes, and that gives me time to check. Ms. Michaud, are you on the phone?
Yes.
There you are. Okay, great. I'm glad we got you. Just hang on. We'll be back in a few minutes and ready for your case, okay?
Okay, thank you.
Okay. Now we all work in the bathroom. Nobody in this office actually smokes. Nobody that I know of. I mean, Nikki used to have cigarettes. I'm not aware of anybody, but I don't know. I have a pack hidden in my house, if that helps you, up above the stove. No. Oh, thank you. Well, as we were walking in, making chit chat about stress smoking, the investigator said, "You know, you're not muted." We just did what we usually do, which is everybody here runs for the bathroom at the same time. Okay. All right, so wait. Okay, so we're missing Commissioner David. Okay, I think we have everybody back. Are the parties here for the next case? I know Miss Michaud is on the phone and I see Mr. Swanson. Yep, I think we're good. Oh, we just need Deb. We need Deb.
I think we're all back. Is it safe to?
Oh, wait, I don't see Commissioner O'Brien right now, so let's just wait a second.
Oh, okay.
I'll just use this time while we're waiting to remind all the attorneys and parties who have left to present, in case you weren't at the meeting at the start, to remind you when you are presenting not to refer to any names of third parties. Basically, any individual or company that is not one of the parties to your case, other than the attorneys who are here presenting. So just a reminder about that. So we've given all of the witnesses and third parties a pseudonym in the reports that we give to you. So just a reminder. Okay, I think we're set.
Okay, all right. Our next case, E20-0266, Sheila Michaud v. Housing Authority of Fort Fairfield. This is a reasonable grounds recommendation. Is there anybody here for the respondent?
Good morning, Commissioners. My name is Adam Swanson, and I represent the respondent, the Housing Authority of Fort Fairfield.
Okay, you have 10 minutes.
Present with me at my office right now is the Executive Director from the Housing Authority, along with the occupancy specialist. We ask that the commission deny the investigators' recommendations and dismiss the complaint. Our fundamental disagreement with the findings really is more about the analysis that's set forth by the investigator. The complainant in this case was not discharged due to a disability. The complainant was discharged due to her absenteeism, combined with her repeated and continued failure to communicate with the respondent. The timeline in this case is very important. The complainant was hired in October of 2010. In March of 2020, almost 10 years later, the Housing Authority received a call from the complainant's boyfriend stating that the complainant would be sick that day. They received a call the following day from the same individual stating the same thing. And then later that day, on March 10th, they received a doctor's note stating that complainant would be out of work until March 16th of 2020. No communication was made by the complainant to the respondent. And then on March 17th, another note was received by the Housing Authority stating that there was a tentative discharge date of March 20th. And the Housing Authority reached out to the complainant to discuss with the complainant about benefit payments while she was out. On March 20th, however, the complainant did not return to work. And then on March 23rd, another note was received indicating that complainant would be out of work until April 6th. Still no word from the complainant. And so the respondent reached out to the complainant on April 6th and asked if the complainant would be coming back to work. Later on April 6th, another doctor's note was received stating that the complainant could not return until May 1st. On May 1st, the complainant did not return to work and again did not communicate with the respondent. Then on May 4th, the respondent reached out to the complainant and had asked when the complainant would be returning to work, indicating that it would be considered a no-call, no-show if the complainant did not reach out to them to make arrangements. Then on that same day, another doctor's note was received stating that the complainant would not return until July 30th. Finally, a doctor's note was received on May 5th stating that she would not return to work until July 23rd. The complainant did call the Housing Authority to make sure that they received these doctor's notes, which they confirmed that they did. On May 5th, on May 6th, the Housing Authority made the determination to terminate the complainant's employment effective May 31st of 2020. On May 20th, the Housing Authority received a letter from the complainant's doctor stating that it was not anticipated that complainant would be able to return to work at all. And that happened before the 31st termination date. The Housing Authority employs 8 people. And it's necessary for them to have the staff to meet their clients' needs. In October of 2015, Ms. Michaud missed 11 days of work. In February of 2016 to March, 35 days of work. 7 days in October of 2017. Now, despite her missing this work, the Housing Authority still gave her a raise. She was then out in 2019 of February for 5 days, and then between May and June, 26 days. September into October, 14 days, and then in 2020, between March and May 31st, out 83 days. The Housing Authority was aware that the complainant was sensitive to certain cleaning materials. And when they were made aware of that, they brought in new cleaning materials or cleaned on dates to work around the complainant so that her condition wasn't exacerbated. That was the only request for an accommodation that was made. And the Housing Authority did that. Once a complainant has established a prima facie case, the respondent must articulate a legitimate, non-discriminatory reason for an adverse job action. They did that in the letter that they sent to the complainant, and they also reiterated that to the investigator. She was not communicating with the respondent to keep them apprised as to when she would return to work. When she was expected to return to work, she did not communicate with them. When she didn't, it was them that reached out to her and said, when are you going to come back? And the only accommodation that was requested was this accommodation for the cleaning products, which was changed. And for the foregoing reasons, we'd ask that the commission find that there are no reasonable grounds to believe that the respondent discriminated against the complainant. And we'd ask that they dismiss the complaint. And I'm open to any questions and reserve what remaining time I have. Thank you.
Thank you, Mr. Swanson. Questions for respondents from commissioners? Commissioner David? You're muted.
Sorry, these notes that are coming from the provider, the medical provider, are they referencing the disability, which I take it is the sensitivity to the chemicals, or they're just saying she can't return to work?
For example, there was some provided as exhibits for our response, but it would say work school release form. This notice verifies that the above identified individual was seen in this facility. Date seen, May 8th through May 13th, 2019. He, she may return to work school after this date, May 21st, 2019. They will return to work with the following restrictions. None.
Okay, so I take it your argument is that she's never asked for an accommodation and therefore never been subjected to the requirement to produce medical confirmation of a disability that qualifies. Is that right?
That's correct. That's correct. And with the caveat that she did ask that they use different cleaning products. Now, to my knowledge, she did not disclose what a disability was and why that was necessary, nor did the Housing Authority ask. But when the complainant did ask to replace or change the cleaning products, they did so.
What's the different question? What's the significance of the decision to discharge on May 6th and receiving the note May 20th saying she may never return to work and that's before the effective date of the termination? What are you arguing about that significance?
It really makes the issue moot. The termination date was May 31st. Before that May 31st deadline came, it was determined that she could not return to work, period. And so there's not a reasonable accommodation that even could have been made for her if she cannot return to work at all.
But the complainant's argument is that the discrimination occurred before that, as evidenced by the discharge on May 6th. Right?
I understand that's her argument.
Yeah.
Yes.
Okay. Thank you.
You're welcome.
Other questions for Mr. Swanson? Commissioner questions for Mr. Swanson at this time? Not seeing any at the moment. Mr. Swanson, you'll have about 3 minutes left.
Thank you.
At this time, we turn to Miss Michaud, and I'm probably pronouncing that wrong.
That's fine.
Okay, Miss Michaud, you have 10 minutes. Okay, remember not to use the names of any third parties or witnesses.
Okay, but I don't understand what more that I can say. I mean, I've said everything. I did what I was supposed to do when I was at work. I was willing to go back to work after my doctor released me to go back to work. And in the process of the time, it came to that I couldn't return back to work. So he just put it so that I couldn't come to work back. And like I said, they gave me the no in March of, or in May, of that I was being terminated as of the 31st of May. Because any other time that I was out on medical leave, when I was able to come back to work, I did come back to work. And the accommodations, there wasn't any more that they could have done. I was glassed in. You have to deal with people with perfumes and stuff on, which bothers my breathing also. So there couldn't have been any other more accommodations that could have been done for me.
Is there anything else you want to add?
No, I think that's just about everything that I can think of, ma'am.
Okay, well, hold on. I'm going to see if any of the commissioners have a question for you right now.
Okay.
Any commissioner questions for Ms. Michaud? Commissioner David?
Ms. Michaud, did I hear you correctly that you just said that there weren't any other accommodations they could make for your situation?
No, sir, because of working with the public, I was right out front. I had to deal with everybody that came in. Part of my job for taking money and stuff like that I did.
Okay.
Are there any other commissioner questions? Commissioner O'Brien?
Yes, just to follow up on that, can you clarify that again? Is it correct that you said there was nothing else that could be done?
And I just want to, I'm sorry to interrupt. The investigator is letting me know that some of this information about the other accommodations and being in the public, that's not in the record. Is that accurate? Yes. Okay. So that issue of whether a complainant could be accommodated in terms of doing her job with regard to chemical sensitivity, that's not in the record. So I just wanted to clarify that. Sorry to interrupt you, Commissioner O'Brien. You want to go back to your question?
If at this point I'm allowed to ask, and I'm not really.
Well, I'm not sure what you were going to ask because I interrupted you.
Just to clarify what she just said, that are you saying that there was nothing else they could do? I just want to make sure that
I don't know what else they could have done.
Okay, all right. Thank you.
I believe, and please let me know if I'm wrong, I believe what Ms. Michaud was talking about is accommodating her on the job versus terminating her for absences. Is that correct, Ms. Michaud?
Yes.
Okay. So the issue of accommodating her on the job, I don't believe is in the record here. Okay.
And the nature of her disability is not in the record. Is that correct?
It is in the record.
Okay. I was glancing back to find that.
It may not be in the investigator's report, but it may be in the record. We try to avoid putting any disability specific information in reports that may become public. Were there any other commissioner questions for Ms. Michaud?
Yes.
Go ahead.
Ms. Michaud, I thought I understood you to say that there was a time that you notified them that that your doctor had said you could come back to work. And my question is, how does that go with the May 20th note from your doctor saying you might never return to work? I mean, what was the sequence there? When did you say you could come back to work?
The last I knew, he told me I could return back to work at the end of July.
Is there a note May 20th saying you may never be able to come back to work?
I don't have it. It would be the housing authority would have it if he said that.
Okay, thank you.
Any other commissioner questions for Ms. Michaud? I'm not seeing any. Ms. Michaud, you'll have lots of time. You'll have 9 minutes left when we come back to you. So just hang on. We're going to go back to Mr. Swanson now.
Okay.
Mr. Swanson, you have about 3 minutes.
As the complainant has stated, there really was nothing else that they could do that they hadn't already done. But when we're talking about her being out of the office, the housing authority does not and cannot offer long-term leave for its employees. And that's due to the limited staffing and demanding operation of the facility and services. They do have a 10-week unpaid leave policy that the person that requires that leave is required to apply for it. Now, in this case, the complainant did not apply for that 10-week leave. However, the housing authority went ahead and processed the paperwork and approved the leave without her applying. The policy at the housing authority requires that an employee either returns to work after that unpaid leave or be terminated. And that policy was also provided to the commission. Now, here, Ms. Michaud was unable to return to work, but the housing authority provided her with a leave that she didn't request. The housing authority continued to pay for her benefits through the 31st of May. And the housing authority was forced to make a very difficult decision to terminate Ms. Michaud. And that decision was based on her failure to communicate with them, to keep them in the loop, and her absenteeism. Thank you.
Thank you. Any follow-up from commissioners for Mr. Swanson? Commissioner questions for Mr. Swanson? Not up. Commissioner Whitworth?
One. So it says in the record here that respondent flatly stated that it terminated complainant's employment because she missed too many days of work due to her disability. Is that correct?
That is what the record states on the investigator's report.
Okay.
However, we disputed that with our response or our request for this hearing.
And could you summarize that for me, please? I'm sorry, I must have missed that. She missed too many days of work?
I'm sorry, I didn't mean to interrupt you.
No, just in one sentence. Why was her employment terminated?
Her employment was terminated due to her absenteeism, her missing work,
Yep.
and her continued failure to communicate with the respondent. So there were, as stated before, times where the respondent was informed she was going to return to work on a certain date. 3 days later, she hadn't returned. There'd been no communication from her doctors at that point. The respondent reached out to the complainant asking if she was coming back, and then they'd receive a doctor's note. And this was a continued practice.
Thank you.
Any other commissioner questions for Mr. Swanson? Seeing none. Okay, Ms. Michaud, you have time. You have up to about 9 minutes if you want to add anything. This is the time to do it.
No, I don't have anything, ma'am, to add.
Okay, that's fine. Do any commissioners have follow-up questions for Ms. Michaud? None of the commissioners are raising their hands, so thank you, Ms. Michaud. I'm going to mute you. Mr. Swanson is already muted, but the hearing's not over, so don't hang up. So that's it from the parties, and then we go back to Kit as the investigator.
Yet, this is my last one. I want to clarify a couple of things. One is this isn't a reasonable accommodation case. This is a discriminatory discharge case. So the other thing is that I believe Attorney Swanson just said there was a 3-day period where complainant was basically a no call, no show, and that is not what's reflected in the record. So we had a tentative return to work date of March 16th. On March 17th, respondent received a note from complainant's doctor saying she'd be out of work until March 20th. Oh no, I'm sorry, on March 23rd. And I don't actually know if that was a weekend or if those are weekdays. In any case, respondent, every time they inquired as to when complainant was going to be coming back to work, would receive a doctor's note stating that she was going to be out for another period of time. Respondent was aware of complainant's disability to the extent that respondent had sort of reprimanded complainant before for not taking better care of her health and for not doing things to deal with her disability. So she was out because of her disability. She was out for a while because of her disability and some disability related conditions. And respondent fired her because she was out because of her disability. And they did fire her before they got the doctor's note saying that she wasn't going to be able to return to work. And it sounds like complainant wasn't aware that that doctor's note was received. So on May 5th, respondent got a note saying that she was going to be out of work until the end of July, and they fired her on May 6th, well before they got the doctor's note saying she wasn't able to come back to work. I hope I'm making sense. I've had a lot of coffee and not a lot of food, so I'm happy to answer any questions that you have and to clarify any of the words that I just said.
Thank you, Kit. Any commissioner questions for the investigator? Commissioner David.
It's not clear to me that you made a finding or that it was the case that the doctor submitted a medical report indicating a disability. I'm looking at paragraph B in your initial statement, said respondent was aware that she was disabled because she told her supervisors and told her supervisors what? That she was disabled, and respondent received paperwork from the doctor regarding her need to be out of work. Did it receive paperwork from a doctor indicating that she had a disability? It seems to me that what Attorney Swanson was saying was that all of these notes are on the form for school or work or whatever, just to excuse this person from showing up.
Yeah, the doctor's notes don't specify her disability. When she called the first time to tell them that she was going to be out, she said that it was because of her disability.
Well, don't you have to document a disability?
They have documentation from it's something that they have in 2019, some medical records that state that she's diagnosed with this disability.
And is that in your report?
It's not in my report, but it is in the record. I was in my report that she told them that she was disabled, and that's she told, yeah.
Yeah, that's that same paragraph that I read, that she told supervisors that she was disabled.
Yes.
I guess I'm confused procedurally. Maybe I need to ask Attorney Hirsch. On the one hand, we have disability cases that require requests for an accommodation. We're saying that that's not this case. This is discrimination based on having a disability outright. right? That she's fired because she's disabled. And
Sorry, I didn't mean to interrupt you.
no, and is that correct?
That's correct. That she was fired because of her disability. Yes.
Okay, it just I don't want to argue with you. It just seems to me that it would be important to note that there was medical documentation of a disability.
You all set,
Yep.
Commissioner? Okay.
Yes.
Any other commissioner questions for the investigator?
Can I just clarify one thing that I said earlier? So there's a note from her doctor saying that she would be back on March 20th, which was a Friday. On March 23rd, which was the Monday, they got another doctor's note saying she was going to be out. So as far as I'm aware, based on the record, there is no like 3-day period where she was a no call, no show or anything like that. Anyway.
Thank you. Any commissioner questions for the investigator?
Yes, one more. Is it the case, as Attorney Swanson said, that she never asked for leave?
I don't believe so. I think she kept giving them doctor's notes that put her out of work for another period of time, but she never made a formal request for, like, under their leave policy for that 11 weeks. I don't believe she requested that.
Yeah, I guess I don't understand what the interaction between those two things is. A doctor saying you should excuse the employee from work and asking for leave. What do they do? Maybe Deb can tell me.
It was, as far as I understand it, based on what Attorney Swanson has said and what's in the record, the employer did that of their own volition without complainant making a request for it at all. Complainant just kept submitting doctor's notes saying that she was going to be out of work for a medical condition for another period of time, which was related to her disability. Yeah. She doesn't have to request like FMLA leave, although to be clear, FMLA doesn't apply to this employer. She doesn't have to request their leave in order to be making a request for time off because of her medical condition. Although again, I don't want to get into the weeds too much of requesting things because this isn't a reasonable accommodation case. It's a discriminatory discharge case. So it's about the fact that they knew she was out because of her disability. They fired her because of her absenteeism, which was a direct result of her disability.
Any other commissioner questions for the investigator? Seeing none. Thank you, Kit. Good job in a lot of cases today. So commissioners, you've heard from the parties and from the investigator. And at this point, we would be looking for a motion.
I'll move that we uphold the reasonable grounds recommendation to believe that Housing Authority of Fort Fairfield discriminated against Sheila Michaud on the basis of disability, and conciliation should be attempted in accordance with the act.
Is there a second?
I'll second.
So it's been moved and seconded to find reasonable grounds to believe discrimination occurred on the basis of disability. Is there any discussion among commissioners? Seeing none. So the motion is to find reasonable grounds. If you say yes, you are in agreement with that. Commissioner Whitworth.
Yes.
Commissioner David.
No.
Commissioner Doosan.
Time. Yes.
Commissioner O'Brien.
No.
So we are in the unfortunate circumstance where we have an even number of commissioners hearing the case. And so the vote is tied, 2 in favor of reasonable grounds, 2 opposed, and without a majority vote under our prevailing standard, our procedural rules prevailing standard, that if there is not a majority vote in favor of a reasonable grounds finding, the default finding is not reasonable grounds. Therefore, it is no reasonable grounds. So the finding on this case, absent another motion, is no reasonable grounds. And to explain that, rather, Ms. Michaud, the commission will send a letter to the parties and their lawyers to explain that the result of today's vote is not a finding that there are reasonable grounds to believe that unlawful discrimination occurred, and to explain your available options under the Maine Human Rights Act. We thank the parties and counsel for participating today. Commissioners, did anyone intend to make another motion? I did not expect so, but I wanted to ask. So thank you to Ms. Michaud and to Mr. Swanson, and that completes that hearing.
Moving on to our last case, H21-055, I'm sorry, H21-0500 ABCD, Richard Kahn v. Hughes School Apartments, Saco Falls Management, Natasha Cannon, and Bath Housing Authority. This is a no reasonable grounds recommendation. Is there anybody here for the claimant?
My understanding, and I could be wrong about this, I believe that the person on the phone with the 603 number is Mr. Kahn. You are muted currently. Is that you, Mr. Kahn?
Yep, can you hear me?
Yes, we can. So, Mr. Kahn, you'll have 10 minutes.
Madam Chair.
Okay. Oh, hold on, Mr. Kahn.
Permit me to interrupt. I'm present now, and if anyone, unless anyone can think of a reason why not, I'll be happy to participate in this case.
Procedurally, there's no reason why you should not.
Great.
Okay, go ahead, Mr. Kahn.
Okay, thank you very much, and good afternoon to everybody. This is an extremely complicated case. Dozens of submissions and documents submitted as evidence. I have extreme difficulty with the numerous distortions and omissions of the record in the investigator's report. In my objection, I specifically requested that the commissioners prepare themselves by reviewing certain documents that I've listed there and certain photographic evidence as well. So initially, I'd like to ask if that has been done, and also to confirm that you have access to the photographs that I submitted in this case on your tablets at this time.
Mr. Kahn, I advised you previously what materials the commission would be reviewing. The commissioners are not going to answer your questions. This is your opportunity to present your objection, and I suggest that you use your remaining time to do that.
I need to know if they have the photos in front of them so I can make my presentation accordingly.
Mr. Kahn, I advised you specifically and
This is
explicitly.
a very simple yes or no question. Do they have the photos in front of them or not?
They have exactly what I told you they would have, which is
You
the
didn't-
investigator's
you
report.
You didn't answer that question directly. Now you can take 3 seconds and answer it yes or no.
I have already answered your question, Mr. Kahn.
Please clarify it for me.
As I explained already, the commissioners have the
No.
investigator's report.
Yes or no, do they have the photos in front of them? If they do, why not say yes? Why are you making a big deal about this? Your answer wasn't clear on that point. Not to me, anyway.
Do you see them as
Yes
an
or no? Do they
attachment to
have
the
the photos?
investigator's report?
Do they have the photos in front of them?
If they're not an attachment to the investigator's report or your submission, then the commissioners do not have them.
Then I object to this because it's obviously critical evidence. What is the basis for not providing them with the photos?
At this point, you're using your
about half of what's
presentation
in the
time.
investigator's report.
Mr. Khan, I'm now running the presentation clock. You are now using your time to make procedural objections, just so you are aware.
Right. So why weren't the photos provided to these counselors, to these commissioners?
As I've already told you, Mr. Khan, I was following our routine process. Commissioners are provided in every case a summary of the investigation via our investigators report and any written objections to it. That is what our commissioners get in every case.
Well, I want to note for the record that at no time did you specifically answer my question in the negative, which is that whether or not these photos would be available to them. You had multiple opportunities to do that. How do we proceed in this case without them having access to the photographic evidence?
You have about 8.5 minutes left, Mr. Khan.
Well, then I'm going to object to this proceeding on due process grounds, not only with respect to photography or photographic evidence, but with many other issues. For example, the investigator's report utterly ignores and does not address my disparate impact claims, my interference claims, my intimidation claims. These things are simply not addressed in any way. That creates a severe due process problem because I am entitled to an explanation as to why those claims would be denied and a statement of a legal basis for any denial. With not having that information, I was deprived of any opportunity to file a meaningful objection, to research any basis for denying those claims, and for including my objections to them in the objection that I filed. So we've got those due process claims. Do you care to comment on that? Nope. Why these claims were not addressed? Why were the disparate impact claims not addressed in the investigator's report?
As I explained to you previously, the report speaks for itself. You can use your remaining time to object to it or not.
Well, let's give a short list of some additional distortions in the record that I object to that depriving of due process. The inspector's report falsely claims that the respondents effectively used polywall to contain dust during the reconstruction, but that's not true. And it's the photographic evidence that disproves it. Let me give you a citation to the specifics. Yes, see photos 1731 through 1780, taken on March 10th through March 14th, that show that no polywall was in place during the plywood, sheetrock cutting, nailing, spackling, sanding process. And as a result, the entire unit is covered with a thick layer of construction dust. Photos 1783 through 1795, taken on March 15th, shows that a polywall was finally installed. And they even did it correctly. Problem was, all the work was done by that point. The only thing left at that point was painting. So the investigator's report is just grossly misleading as to what was done, what protection was afforded, and what wasn't. Also related are photos 1618 through 1645. During the demolition phase from March 1 through 2, there was a partial polywall, but it wasn't complete, and it was down by March 3rd. Bottom line, there was no effective polywall during any of the reconstruction, and that's how the place got disgustingly filthy. The investigator's report falsely states that the respondents offered the use of an industrial air purifier. That never happened. During the issues conference, both Natasha Cannon and I disputed that. We had no memory of anything like that happening. This illustrates the investigator's penchant for fabricating facts based only possibly on unsworn statements in counsel's position letter that are not supported by any statement or evidence by people with actual personal knowledge of the matter in question. The bottom line, it's a rip and read operation. She'll take whatever she wants that's useful to her predetermined outcome in this case, and not care whether it's actually supported by any witness statement or any documentary evidence. So no, that offer was never made. She uses snarky quote marks around the term off-gassing, as if off-gassing is something that I made up. It's not. It's used by the codes enforcement officer and by all the literature. And whether a smell is mild or noxious, it's a form of off-gassing. Maybe you'd like to explain later on why you felt the need to put the word off-gassing in quote marks, if not to look snarky. You said that there were, you said that I claimed that there, quote, I repeatedly claimed that there were dozens of witnesses in this case. No, I never said that once, so I don't know why you would say I said it at all, let alone repeatedly. But what I did say is that there are about a dozen tenant and non-tenant witnesses who, at my invitation, came into the apartment and observed the stinking off-gassing for themselves and indicated their willingness to give statements and even to appear in court. I understand that you haven't contacted any of those witnesses, and you haven't explained why. Those witnesses are crucial, like the photographs, to corroborating my case. So the bottom line is, and I have such a long list of these things, and many of them are discussed in my objection, but I absolutely demand that this case be reopened, that a new investigator be assigned, somebody who will be competent and recognize the need to prove evidence like this in front of the actual decision makers, which is to say the commissioners. So I see from discussion in previous cases that there is a procedure or a practice of reopening cases when there are procedural difficulties or evidentiary disputes, and that certainly needs to be done in this case. So most important, the last thing before I'll open up to questions is you have to read my doctor's February 24th letter and April 22nd letter, where she describes the effects of this off-gassing that was continuing in the apartment as catastrophic effect on my health. And also my insurance agent's June 2021 written statement indicating that even months after this carpet was installed, it was emitting a strong chemical odor, and that in the other room, the bedroom office room, there was a different odor, which was, quote, only slightly less overwhelming, unquote. None of this stuff is properly quoted or attached. You people, commissioners, I feel sorry for you. You can't possibly make a reasonable decision in this case. And you know what? If your procedural rules somehow prevents you from seeing photographic evidence or reading complete copies of doctor's letters, this is a kangaroo court. Okay, open up for questions. Or I reserve the rest of my time, and if you want to ask questions, you can.
Thank you, Mr. Khan. Commissioner questions for Mr. Khan at this time? Any commissioner questions for Mr. Khan right now? I am not seeing any. Mr. Khan, you'll have about a minute and a half when we come back to you. Now we have two respondents' attorneys here, and I have no preference about who goes first, so I'll let you two duke it out there. And if you could clarify which respondents you are representing.
Sure. So hello, commissioners. My name is Bill Ware, and I'm representing respondents, Sauk Falls Management and Ms. Cannon. I believe me and co-counsel have already talked. We're going to split up the time, if that's okay with you, Amy.
Perfect. Thank you.
So good afternoon now, I guess I should say. Contrary to what Mr. Khan has alleged, this is really not that complicated of a case. It's actually, in fact, a very simple case. So the backdrop of this case is that Mr. Khan's claims are premised mostly on common tenant landlord tort claims, and he's attempted to shoehorn these claims into the Maine Human Rights Act, which is not appropriate. These claims are also born of an overly litigious attitude that Mr. Khan has takes issue with any disagreements towards him. And as indicated in the commissioner's report, he's submitted or plans to submit claims against at least a dozen entities, some of which have no involvement in these issues. And in this light, it should be noted that the majority of Mr. Khan's objection to the investigator's report is not about the substance of his claims, but rather attacks on the investigator's professionalism and her fairness towards him. Again, which just repeats this theme of being over litigious and taking issue with any perceived slight. And so just to correct a few things that Mr. Khan put forward, he takes issue with the investigator's report not touching on certain claims. That's not accurate. Again, Mr. Khan submitted various materials to the investigator and concluded, and a lot of those materials are just conclusory allegations. For example, he wanted her to look into defamation, fraud, Maine Unfair Trade Act, and so forth. So the disparate impact claim, he hasn't substantively put that forth because he's offered no statistical evidence to support that, which is necessary to sustain such a claim. And again, if you look at his objection, they're all personal grievances tied to him by himself, not a class-wide basis. He did not put it forth a substantive claim for intimidation or anything like that. In terms of his actual claims, so he had presented a claim for disability discrimination and in terms of terms, conditions. However, he didn't show that Saco Falls or Miss Cannon treated him any differently from any other non-protected class. Rather, as was its standard procedure, Saco Falls worked diligently to try to fix the water leak and then worked with Mr. Khan afterwards to try to address the issues he claimed he was having. There's also no failure to accommodate. Again, even assuming that Mr. Khan has a disability, which is what the investigator did, all his requests were granted. And the only request that was denied was the request that Saco Falls had already completed, which is that he wanted the same carpet that was installed prior to the water leak to be in his apartment, which it was. And so this was confirmed by the Maine State Housing Authority, the Bath Housing Authority. There was nothing defective or wrong with the carpet. It was the same make and model, different color. And so, again, that's not a failure to accommodate claim. In terms of his retaliation claim, again, it was premised on different lease terms. However, it was shown through the investigation that the lease that he's taken issue with was drafted prior to this incident and was used by with all of Saco Falls management's tenants. So it was nothing specifically directed towards him. And lastly, they did not make housing unavailable to him. He admitted that he stopped paying rent for 2 months, and that's what prompted him to leave. And in fact, Saco Falls overcompensated him by giving him more than was allowed on a security deposit. So, while there is a lot being thrown at you, I encourage you to wade through the fog and see these claims for what they are. And so in that light, we would urge you to adopt the investigator's findings.
Thank you, Mr. Ware. I'm unsure how to do this best. I guess if you don't mind, I'll ask commissioners if they have any questions for you, Mr. Ware, and then we'll go to Mr. Rudman. Commissioners, any questions for Saco Falls Management and Natasha Cannon? Not seeing any. You have about half a minute left when we get back around to you, Mr. Ware. So now, Mr. Rudman.
Thank you. My name is Sam Rudman, and I'm here representing Hughes School Apartments and Bath Housing Authority. Bill has accurately put forth Hughes School Apartments arguments. I won't repeat them. Hughes School Apartments basically employs Saco Farms management to manage its properties, and as the investigator said correctly, any involvement that Hughes School Apartments had with Mr. Khan was actually through representatives of Saco Falls management. With regard to Bath Housing Authority, we agree with the investigator's report that the Bath Housing Authority didn't perform any repairs. In fact, the most involvement they had with this case was a day or two after the actual water infiltration. And Bath Housing Authority has a contract with Saco Falls Management to perform minor repairs. What they did here was just recommend some contractors, and that's it. Mr. Khan really had no contact with Bath Housing Authority except to ask for information down the road. Bath Housing Authority had no input at all in Mr. Khan's decision not to pay rent or in any decision to evict him. And so we agree with in the entirety with the investigator's report and ask you to adopt it. Thank you.
Thank you, Mr. Rudman. Any commissioner questions for Hughes School Apartments or Bath Housing Authority? Not seeing any. Okay, so then we come back to Mr. Khan. Mr. Khan, you have about a minute and a half.
Okay, I'll try to do that. I never raised any tort claims until January of this year when I received the respondents' position letters. They asserted a defense based on lease provision languages, which was conditioned upon there not having been negligent or intentional misconduct. So that raised all of these tort law issues that I brought up. In order to resist that defense, I had to show that they were not entitled to it because their conduct was negligent or intentional. At no time will you see any discussion of tort claims in my pleadings prior to that. The only other relevance of tort claims is that it goes to credibility. These people are engaged in a criminal enterprise here by falsely claiming that they were not responsible for the flood when Bath Fire Department's February 22nd, 2021 report clearly indicates that they were responsible for it because they didn't know how to turn the water off and the flood ran for an extra 2 hours. But they lied about that, and they also lied so severely about BHA's involvement during the flood itself that counsel had to withdraw from the case, original counsel for BHA. They have severe credibility problems, but of course the investigator doesn't want to touch on any of that. And my last question is, has the commissioners in any case ever been provided with photographic or documentary evidence in any case? And if so, why not in this case?
So Mr. Khan, that's your time.
Okay, I expect an answer to that question.
I'm sure that you do. I will now be muting you. So I believe the investigator will be happy to address, if the respondents do not, any of the issues that were just raised, things that weren't in the record, things like that. Before we move on, do any commissioners have any questions for Mr. Khan? There are no commissioners indicating that they have questions for Mr. Khan. So then we would go back to Mr. Rudman. I'm sorry, Mr. Ware was next. Mr. Ware, you have about 30 seconds.
Nothing else to subtly respond to. I'll let Sam comment on the Bath housing allegation.
Okay, I'll let you two finish up together and then ask commissioners if they have any questions for the both respondents generally. Go ahead, Mr. Rudman.
I don't have anything to add.
Oh, okay. Any commissioner questions for either Hughes School, Bath Housing Authority, or Saco Falls, Natasha Cannon? Any commissioner questions for respondent? I am not seeing any hands raised, so I will thank complainants and respondents for their presentation, and we will turn to the investigator, who is in fact, I believe, quite competent.
Thank you, Amy. Good afternoon, commissioners. My name is Jane O'Reilly. I was the investigator on this case. I apologize that I couldn't get the lighting fixed so that you can actually see my face. I feel like I'm in shadow, but I don't have anything to add. I'm happy to address what was submitted to me, how I looked at it, how I considered information. I will just say that the final statement made by Mr. Khan regarding the council for Bath Housing Authority withdrawing due to some kind of misconduct. It's not in the record, is false as far as information that's in front of me. It's very common for attorneys to change. I received a very standard withdrawal and appointment of an attorney. So I just wanted to make it clear that that was not part of my understanding of what occurred. And again, I'm happy to answer any other questions, but I have nothing additional to add.
Any commissioner questions for the investigator? Commissioner questions for the investigator? Just checking one more time. I do not see any hands raised. So since you, thank you, Jane. Since we've heard from the parties and the investigator, we would be looking for a motion. Yeah, there are two proposed findings here. So either a motion or motions. Commissioner David.
I propose to take them together and move that we find there are no reasonable grounds to believe that the respondents by name discriminated on the basis of disability, denial of reasonable accommodations, terms and conditions, or constructive discharge, and that there are no reasonable grounds to believe that respondents by name retaliated for Maine Human Rights protected activity.
Is there a second?
Second.
And just my own personal comment to Mr. Khan, this report is extremely coherent, consistent, raises no doubt in my mind that it is fair and impartial in stating the facts, and includes an appendix showing a significant and detailed investigation.
Any other discussion by commissioners? Seeing none. So the motion is to find no reasonable grounds on both sets of claims, discrimination, disability discrimination, and retaliation. If you say yes, then you are in agreement with the no reasonable grounds finding. Commissioner Whitworth.
Yes.
Commissioner Ashby.
Yes.
Commissioner David.
Yes.
Commissioner Doosan.
Yes.
Commissioner O'Brien.
Yes.
So the findings are both no reasonable grounds. The commission will send parties and council a letter confirming that. And we thank you for your participation in the hearing. That ends our hearing agenda. And so at this time, I am hopeful that we will have a motion to go into executive session that cites the relevant part of the Freedom of Access Act.
Pursuant to 1 MRS Section 405-6E, I move to go into executive session to consult with our attorney regarding pending and contemplated litigation and the legal rights and duties of the commission.
Is there a second? Okay, thank you. So it's been moved and seconded to go into executive session. If you say yes, you are in agreement with that. Commissioner Whitworth?
Yes.
Commissioner Ashby?
Yes.
Commissioner David?
Yes.
Commissioner Doosan?
Yes.
Commissioner O'Brien?
Yes.
Okay, I am going to attempt mightily to move you all over into executive session. For the other folks who are still on here, the meeting will continue. This YouTube stream and Zoom meeting will continue, but you will not see the commissioners and the other folks who are going into executive session pursuant to the Freedom of Access Act. When we are finished with executive session, we will come back to this meeting. So here we go, trying to open the breakout room. Hold on, I need to do one more thing. Okay. You will be invited to go to that meeting, I think, hopefully. Okay, we have 2 commissioners. Hopefully, the remaining commissioners will be returning shortly. There's Julie. There's Deb, and there's Jill. Great job, everybody. Okay. So we need a motion on litigation matters. And you can reference the recommendations if you don't have the precise case numbers. And we'll fill in the details.
I move that we adopt the recommendations of council, that we litigate the one case, housing case that we're required to litigate involving assistance animals, which I don't have the docket number for, and not litigate the case that she advises against litigating.
That's a good motion. I like it.
Way more concise and pleasing to just go with, I vote that we do what Barbara said.
Don't do
for
that.
next
That's
time.
a terrible idea. Deb, I thought I saw a second there.
Yeah.
Okay. So it's been moved that we not litigate the reasonable grounds case of PA 200057 Caterino versus the Northeaster Motel, and that we do litigate, because we're required to do so, HED PA 210319 Fagan versus St. Joseph's College. It's been moved and seconded. Is there any discussion? Seeing none. If you say yes, you are in agreement to both of those recommendations. Commissioner Whitworth,
Yes.
Commissioner Ashby,
Yes.
Commissioner David,
Yes.
Commissioner Doosan,
Yes.
Commissioner O'Brien.
Yes.
Okay, 5-0. I believe that is our last matter of business. And we don't need a motion to adjourn unless you want one. Okay.
Thanks, everyone.
Bye. Thank you,
Thank you all.
everyone.
Thank you.
Bye.